Hi everyone. Good morning and welcome to Umbrella Saturdays. I would be introducing myself. I'm the speaker for today. My name is Ayola Oguyomi. I'm CEO, co-founder, Umbrella. Um, then we start. So Umbrella Saturday is a high impact weekly Zoom webinar for some of us that's joined us in the last two episodes that we've had. We've been able to cover from books to box with the Intense team. And then we moved to from vision to valuation. And today we'll be doing um, Lega Armor for startups with the Scott Lega team. Just quickly run through my slides, just basically just introducing what we do here. Like I said, I'm Ayola. I have over 14 years experience in branding, marketing, and building both brands, businesses, people. And then as well as I'm an investor. I've also been a founder. I've worked in some of those companies that you see, started my career across those businesses. Um, and then, of course, I'm a founder, just like some of us on this call. I've run a business for over 6 years. And I've had two startups, Apate being one, and then Umbrella being the second one. We have something else in the pipeline that we're working on. These three sessions have held, like I said earlier. We had two people from Intense who basically took us through financial discipline to drive fundraising. We've had Ayo Akindele, who also did justice to from vision to valuation. And today we'll be having someone I hold very dearly. She's advised us as Umbrella, and she's also done some, due diligence, some great work for us at Umbrella, and that's why she's going to do justice to this topic today. Um, I would also basically just run through the slide, like I said. Who is Umbrella for? Basically for startup founders who are seeking clarity, mentorship, and access to real-world experience and expertise. Investors who are scouting high-quality deals and verified African pipelines of startups at all across all stages. Of course, ecosystem advisors and operators who are looking to share knowledge. And then we also have corporate partners who are aiming to offer their services, right, or position as leaders to gain potentials into the new world of innovations. What's in it for you as a founder? Of course, you have access to industry experts and actionable insights, free platform to pitch your ideas and receive live feedback from our speakers. Of course, you also get exposed to investors and key ecosystem players who are subtly on the call most times, who are not saying much, but they're also listening to you, founders, when you introduce yourself or when you have something to say. Investors, of course, have the direct channels to connect with verified pipelines and investment-ready startups. Early access to deal flow for investors, and of course, sector-focused conversation to match their investment thesis. We have speakers and advisors who basically gain visibility among Africa's emerging startup talents. We also have the opportunity to influence startup thinking and direction, which of course we're trying to shape responsible startup founders in Africa, and of course partnership opportunities with Umbrella and the startup in Umbrella. Why should you be a part of this? Of course, Umbrella is built on trust and creation. For most of the startups who have been through our investment readiness and pipelines, you will see that the core of what we're trying to do at Umbrella is to get all startups, all speakers, all content vetted, and of course, relevance and then of quality. We're founders first with our format for everything that we do. Every session is designed to provide a real value to founders from insights all the way to investment. And then there's also a consistent deal flow for investors and also our partners. Each webinar serves as a soft demo day, giving investors regular access to created startups. Um, What makes us different? We're community powered, we're data driven, and our partners can see this on the call. Even while we try to do a lot of things at Umbrella, we collect insights before and after every session to continuously improve and match founders' knowledge and for capital as well. Of course, verified pipelines, startup futures come from Umbrella's broader ecosystem with strong onboarding standards and, of course, advisory support. And then multi-stakeholder experiences. We combine learning, networking, and matchmaking in all one simple platform. Welcome to Umbrella Saturday. It's not just a webinar, it's also a gateway to early startup deals, sorting, expert insights, and of course, startup investor matchmaking. I'll stop there. Just quickly give us some insight into some other things that has happened when we started, because we're wrapping up for the month of May. And usually we share this data with our partners just before Titilayo Aina-Scott comes in. Of course, we had over 154 respondents, and each session has had over 20 attendees. From founders to investors to advisors to directors, dreamers, people who are just trying to start out, prospects, who are just trying to look for businesses. Of course, researchers who are trying to get into the African ecosystem, and then people who are just starting out. We've also seen the stages. Of course, we have a lot of early stage founders, which amounts to 42.3%, pre-seed, seed, as well as growth stage. So was sector agnostic at Umbrella, and then this means that we have a wide pipeline of founders within the ecosystem who are interested in this. We looked at the sectors, which most of the founders that are interested in this Umbrella Saturday have been through, from fintech to health tech to food tech, all the way down to social impact NGOs, and we've had a couple of them on the call as well. Also, just trying to find out from the founders what role they play. We've seen solo founders, we've seen co-founders, two founders, two co-founders, three co-founders, and the likes on Umbrella Saturday. We've also tried to see the role in which the founders play. Of course, we have a bunch of them, of the founders on the call who are not non-technical, but of course they have technical co-founders. And then some of the biggest challenges, right? Which of course is one of the things that also drives the sessions that we've had. We see from legal to regulatory challenges from founders, fundraising to financial access, market validation and user acquisition, sales, talent hiring, technology operations, international expansion, governance, and the likes. And this also just informs the kind of speakers that we bring to Umbrella Saturday. And then I would just quickly skip. Of course, investors as well also showed their interest. We had two angel investors show their interest, and of course, some VC members. Of course, we also reached out to a couple of people within our pipeline of investors who we didn't send the form to because they already exist in our pipelines. So what stage of startup do they invest in? Idea stage. So if you're an idea stage founder, be sure that you also have investors who are interested in investing in your ideas as well, or even taking a look at what you're trying to do. Pre-seed and then seed stage founders. So I will just stop there and then do the introduction to TT. Titilayo Aina-Scott is a very close friend of the house at Umbrella. She basically helps Umbrella. She's our partner. She helps us with our due diligence. She also helps us with legal and a lot of compliance navigation within our team. So Titi, I'll just quickly yield the mic. And if I know you have a document to share, so I would also grant you access to share, so you can also share while I stop sharing. Yeah, Titi, over to you.
Okay, thank you so much, sir. Thank you for the introduction and what I say compliments. I think we wanted you to help us share
Oh, okay, that's great. I can do that. Let me just download that and share.
all right, thank you very much.
But
Okay,
while
well that
that's
has
done,
been
sorry.
done.
Yeah.
Okay, go on, sir.
Go ahead, go ahead, go ahead.
All right, so while that has been done, I want to welcome everyone to Umbrella Saturday. I think this is the last for the month of May, and it's legal. Um, I want to thank Mr. Ayola for the work they are doing. I've always been a firm believer in the fact that no one should just start up a business just like that without any information at all. And that's what some people do most of the time. They just start up, they are without any. So along the line, they get into one trouble here, one trouble there. They learn by experience and then, and start to move on. But I think, while starting up or, before you even start up, acquiring a lot of knowledge that would help you, it's very important. So I appreciate the work that Umbrella is doing with the Umbrella Saturdays. And another thing I really appreciate is the data that was supplied. I mean, that we have just gone through. I found the data extremely interesting. The startups that have signed up for these Umbrella Saturdays and their areas of focus, and of course, what they believe is most important to them. In the first data that was shared, I saw that, I mean, a lot of the founders, even in this one, a lot of the founders believe that fundraising is their major challenge, and legal, it's just by the way. Okay, so but we want to try to find out whether legal is by the way and fundraising is before legal, or you have to put legal first so that you can position yourself better for the funds you want to raise as a startup.
Okay,
So
let's do this. Let's do this.
go ahead.
I like to let people see the face of the speakers. I know
Oh,
we didn't allow Ayob do that because he was using his phone, but Titi, let the world see you, and see the madam that is doing a great job at Scott Legal. And so
you're
I'll
right.
move your slide. I'll move your slide when you're ready to pivot.
All right, thank you. Okay, so it's a Saturday, so but I still believe I had to show my face, so I did dress up for the occasion in that sense. All right, okay. So yeah, please go on to the next slide because I have a bit of introductions.
All right.
Right. So I've been introduced already. My name is Titilayo Aina-Scott. I've been a lawyer now for 18 years and with varied experience, ranging from commercial practice to litigation, dispute resolution, and of course, technology law. I use my experience to advise clients, startups, businesses, multinationals on their legals and how to position themselves and how to ensure that they get things right, while doing their business. Next slide. I'm the managing partner, Scott's Legal. Scott's Legal is a law firm. We're a twin law firm, like I like to say. We have the commercial and dispute resolution arm and the technology arm, which my colleague Dumebi is in charge of. And Dumebi is also on this in this call. We provide services to, wide range of clients. Our clients, they're from big multinationals to startups like you. In this call, we have so many startups. We have prop tech. We have a varied clientele: prop tech, GIS tech, food tech, health tech, fintech, different prop. We even have a prop fintech client who is merging prop tech and fintech, together. So we have quite a varied clientele when it comes to our technology law practice. We also partner with different umbrella has already told you the kind of work that we do with them, and we appreciate the privilege we have to do those work. We also have other partners. ICANN BOI is, one of our partners. Night Ventures, we were the ones who did some of the diagnostics for their last cohorts. Then we have Impression Hub and several other hubs like that that partner with us, to provide services to their startup. So we are very well grounded in this. In this next slide, please. Even I didn't get that question.
All right. So I someone said it couldn't hear, so I just wanted to confirm if it was not a general problem.
Oh, all right. Okay. Can you hear me now? All right. Okay. All right. So we're looking at legal framework in Nigeria. Like I said, when I looked at the data, I saw that a lot of founders are very concerned about raising funds. And of course, capital is the life of any business. Without capital, nothing can happen to your business. But we also need to look at what leads to raising funds and what you need to put in place. The first thing I like to say when I have an opportunity to speak at events like this is to say that a business is a legal creation. You have to deal with that. When you call something a business, it's a legal creation, and that's why the CAMA 2020 provides, from formation to the death of a business. The CAMA takes care of that. We're talking about business names, talking about companies, limited partnerships, NGOs, whatever business model you want to adopt, it is a legal creation. So let me ask you a question. Why would you pay money to Umbrella? Umbrella is not a person, okay? If I pay money to Mr. Ayola, I can hold him and say, look, sir, I paid. But when I pay to Umbrella, Umbrella is not a human being. But the law recognizes Umbrella as what we call a legal person or a juristic person. So because of that recognition is the reason why you can deal with businesses in the first place. So to sideline legal when you are, starting up, is you are not even doing yourself any good, because what you're about to start up, the formation to the winding up of a business is a legal, there are legal issues. So we have the Company and Allied Matters Act, the key legal frameworks that we have: Nigerian Investment Promotion Commission Act. That is, if you are getting foreign investors, you need to pay attention to the NIPC Act. We're looking at tax laws and regulation. We're looking at intellectual property laws and, of course, employment laws. Sorry, today is a Saturday, so you need to please give me a minute to attend to my kids. They're knocking on the door.
All right, let's just give Titi some minutes to just sort out kids matter. She's doing great, combining mom's duties. That's a lot. Titi, I just have one joke for you. If the maybe it's on this call, Titi. So when your kids disturb like this, do you charge them to court?
I'm sure they don't even know the import of being a lawyer yet. They just know their mom is a lawyer. They don't know what it means. Okay, all right. Sorry about that. All right. So why does legal protection matter? And we have said that startups often overlook, legal matters in a rush to build MVPs. A lot of people here are at MVP stage. We're at MVP stage, and we're already building a product, something you want to sell. You want to raise funds, you want to grow. That's what is usually paramount in the mind of every startup. But sometimes you say, okay, we'll do this later. But those delays can be risky in any event. Those you even want to deal with, the investors you want to deal with, they want to know that you are intelligent and you know what you are doing. So to ignore legal and try to deal with an investor, as an investor, I'm not sure, you'll be taken too seriously. So we have said that legal issues are one of the top 5 reasons why startups fail, and that is a fact. Co-founder conflicts, IP thefts, regulatory issues are some of the reasons why startups, fail. So we gave a case study, Paystack by Zap, and I know that from the data we received, a lot of people here are they are fintechs. Majority, from the data are fintechs. And what Paystack had done, Paystack Zap, they have a switching license, and they didn't, that doesn't give them a right to keep deposits. So what they did was to partner with like Titan Trust to do the Paystack so they can take deposits. And CBN said you can't. And I know that a lot of fintechs here are doing that, because I have clients who are also doing that. They say, okay, look, we don't want to get the CBN licenses yet. What are we talking about? 250 million for a license. Let's keep that aside. Let me just partner with another bank, and since they can take deposits, I'll just partner with them. It looks good, but now the regulators are saying no. So that means you have to start looking at what you are doing again very well.
Questions start now, because we are all going to throw you all our legal debts,
Please
And
go
I have the
ahead.
first question, right?
Go ahead.
I am I am legally binded, let me use that word now, in a founder's mindset. And please, guys,
Okay.
if you want to ask questions, just use the raise your hand buttons. We would allow you to this session to speak. I know that Titi is going to do justice to this conversation. Let me have my camera on for those who haven't seen my face. Um,
Problem.
right. But Titi, my question is, I've signed an NDA, an MOU, an SLA. I'm joined by in the hips with this, let's use the past conversation with Titan, right? And I'm
Yeah.
tapping APIs, right? So Titan is the one collecting it. I just have the infrastructure. APIs have connected two of us together. I still need a license.
No,
Money
that's what
doesn't
CBN is saying.
The
I'm
money
not the
doesn't
regulator.
see.
CBN is the regulator. CBN is saying that's not sufficient enough to collect deposits from people. It was, I mean, I have fintech clients, and those are some of the things we used to tell them. Say, look, you don't have to go and get the license. Just partner with a microfinance bank and all that, and let's just, But now the regulator is shining their light on that. So that's how regulators are. So you might think, okay, well, I'm not doing anything. They are the ones collecting the money and they have their licenses. I'm only just partnering with them. But CBN is saying that is not enough. And what was the fine against, it's not
Paystack,
up, I don't know, maybe some
millions.
hundreds of millions of naira, that they have been fined. So, I mean, that's what the regulator is now saying. So, of course, you know that when it comes to technology, it's a growing space, and the regulator is also always trying to catch up.
Mhm.
So I'm sure that Paystack and their legal and their assistants will start talking to 250 million. Thank you very much. They'll start talking to the CBN now to say, okay, look, this is what we're doing, and then they'll start looking for a way to get what kind of license can fit that kind of thing. But I'm only using that as a case study to show you why, I mean, why you cannot ignore. I mean, it was an assumption on everyone's part that, look, in as much as I'm not the one collecting the deposits, I'm okay. But now the regulators are saying no. So that shows you that it's not something you can just drag to the side. You have to pay attention to it. So what we're saying is that legal protection builds trust with investors. It provides clarity with co-founders. It's I mean it protects you against exploitation, and it gives you some regulatory confidence, because when you are we had a client once who said he was doing the same thing, but he said, look, get me a cooperative bank license. I mean cooperative license. Get me any all the little licenses he can get, even though he was going ahead with this model of partnering with another bank. So, but he just said, look, in case the regulators come after me, I can say, look, I have this, and I have this, and I have this also. So sometimes when you pay attention to some of those things, it gives you some regulatory confidence.
All right.
So being
So,
legally ready can
Another
make.
question. Another question.
Okay,
Another question.
another question.
Yes,
So
another
let me
question
keep up
for
with
you.
it.
Another
Go
question.
ahead.
No, no. I will read the questions in the chat for you if there's anyone in the chat. But another question, Titi,
All right,
right?
go
Uh,
ahead.
my concern here is I'm a startup. I'm a startup. The word startup, I am just about to get out. I have not even figured how I will run this thing, right? I am
Yeah.
bootstrapping. Keyword, bootstrapping. I have maybe some money I've um put aside, right? I want to run this. Now, can I even just start and maybe try to put in an application for this license? Can that stand while I'm doing the API connection with somebody? I have an application with maybe SEC or CBN for the license, but I don't have the funds. I want to do business, generate some revenue, and then get this funds, get this license. Can I do that legally? Are there ways
Well,
to
I mean,
navigate it? I know doing business is hard. Well, and then we also need to understand that this is not just a Nigerian problem, it's an African-wide problem. And I'm sure that we have some founders in other countries. I just want it to be as straightforward as possible. Richard will take your question just after Titi is able to answer this. Or Titi, do you want to merge the questions together?
No, I heard you. You're saying, okay, look, I want to apply while I'm going on with the business, and that, as far as I'm concerned, is a no. The
Hey,
reason why it's going to be a no is because now there are different spaces you can play in, and that's why, as a startup, you must know your space. You must know what I mean. What if you want to start a fintech? It's a capital intensive project,
hmm,
and you have to admit that.
mhm,
So, and that, I mean, it is capital intensive. So, but there are some other aspects that maybe you can try to look at that may not be as capital intensive as the other. I mean, so, but you have to look at the space you want to play in. And that's why, I mean, I mentioned Night Ventures the other time when we had to do some, like what we call a legal diagnostics. Is something that is peculiar to us. We do this legal diagnostic for you to say, look, this space you want to play in, do you know the regulators? Do you know the laws? Do you know, I mean, the things that you may need to do? So we produce that document that will tell you maybe like your I mean your long-term plans, legal plans, your mid-term legal plan, your immediate legal plans that you should have as a startup. So that gives you like a wide understanding of, okay, this is where I'm going to, this is what I can do in the meantime, this is what I cannot do, this is what I can do, this is what the law says, and it allows you plan your regulatory compliance. But to say, okay, I've already made an application, and let me give you an example. How many of us know the Synagogue Church of All Nations, SCOAN?
yeah.
There was this issue they had a while back when the building collapsed.
Hmm.
After that building collapsed, the Lagos State government took them in, filed a criminal action against them. My law firm at the time were the ones defending SCOAN in that dispute. And you won't believe what they raised. They said they applied for the building approvals, but they never got it and went ahead with the building.
Hmm.
So, but it was when the issues happened that the government now said, look, yes, you applied, but you didn't get our approval for this building. So you are criminally liable for the debts that occurred. So you starting, I mean, the process of an approval and not completing it is not good enough. Except, I mean, there are some processes you will start. The government will say, go ahead and continue, then come back for there are processes like that, but there are some that you might need to wait for the approval before you. Um, okay, someone
Let's
is
let's
saying
have
he's not
let's have
sure it was their fault the approval didn't come out on time. Yeah, but then they went ahead with the building, and just
okay.
as it is with risks, the building came down. So the building came down and killed over 100 people. So that means, yes, you applied for the approval. It's not your fault that the approval is not out, but you went ahead to build without the approval. So that's what I'm trying to say. That sometimes just trying to go ahead without your approval may also not work. In some instances, you might be able to go ahead with it. For example, now, I mean, some of our clients they're building, they have a large scale go ahead while they're still doing other things, but they have a go ahead notice to say you can go ahead. So there are things like that where you can get a regulatory go ahead while other processes are still in place.
All right, let's have Richard. Let's have Richard. Richard, you can unmute yourself.
Okay, thank you very much. Good morning to also.
Good
My
morning.
name is Richard Afolabi. I'm the co-founder of Becca AI. So I'll give you a backstory, a little bit of a backstory, then ask my question. So in 2019, I was working with an agri-tech company and they had some issues with crowdfunding. And just the altering, so I came up with the concept, okay, instead of we going for crowdfunding with equity, which was under SEC's purview and it was against their regulations, let's come up with a concept called non-equity crowdfunding, which they were not regulating at that time. We're able to use it to raise some funds and we got what we needed. But later they came up with a concept that like was regulating that same idea. That comes with the idea that okay, like you said, the government will always catch up with most founders in such situations. My own question now is, in a situation whereby you've already been able to create an alternative, for instance, like what Kuda did with the whole cooperative thing, and also with MFB licenses
Mhm.
that helps them just get in one state and use like tech to make sure that every other person can use the solution remotely. How do founders create this balance? Because for me, I saw someone writing that Nigeria, that problem is not Nigeria only, it's a worldwide thing. You even limit it to Africa, like it's everywhere in the world. Regulators will always come up with regulations because of new innovation in certain places. So, how do founders create balance, especially in a climate like Nigeria, where sometimes it could be like they are witch hunting you because of your innovation? So, how do we create balance in such situations, please?
Okay, thank you very much. I heard you mention Kuda, but you know Kuda has a microfinance bank license, which allows them to take deposits. You
Mhm.
know, they use tech to scale. So, but we know what we're talking about here is you don't have any license, but you want to partner with another bank and then take deposits and put it in the other bank while you're also dealing with your own customers. So they are slightly different. So how do you strike a balance? I'm going to advise you. The first thing is get a diagnostic. You don't know the law that regulates your space. You don't. But a lawyer can tell you, look, this space has these regulations, and these regulations, and these regulations. This is what you can do because sometimes some people believe that, I mean, maybe lawyers are, they might make things difficult, but it's not true. If you have a business lawyer who is business minded and wants you to also succeed, they can say, okay, well, you can't do this, but you can do this, you can do ABC, but you can't do D, you can't do E yet. So I think a diagnostic it just gives you a good idea of what is exactly is going on in your space and what is permissible and what is not permissible based on the things you want to do. So as a founder, I'm going to advise you that look, a diagnostic would help you. It will help you navigate, the terrain to help you be aware of some of the regulatory, challenges you might face, and then you can also, adjust that.
So one quick question. One quick question. I hear you.
I think I'm going to take my slides today.
You're going to
Okay,
take
but
your
go
slide.
ahead.
So the thing about Umbrella Saturday is that the conversations they're real, right? You're going to be hearing a lot of founders speak. I'm even waiting for some people in the room to start talking before then maybe you might just have to attend to your kids after after a while. But the truth about it is that at what stage is it when I'm thinking about the idea or when I'm even trying to do my product or even drawing my product roadmaps or even building the designs on Figma? At what stage should I even bring in legal? I think that's the question in the room. At what stage should I bring in legal? Because again, legal is expensive. It's not cheap, right? Unless I want to do a charge and bill lawyer, right? Or I want to work with maybe I know a friend or a cousin who is a lawyer who is willing to help me out. And sometimes if things are not, in my own opinion, if I'm not paying for it, I don't think I get the best value. The person does something for me. I don't know, in my own opinion, right? But if I'm paying for it, I can scrutinize and ask questions and say many, many things just so that I get the value for it. My point to you, at what stage should founders, because we have early stage founders here, some founders maybe decide to get lawyers when they had likely possibility of disputes within their team or outside the team or with partners. At what stage should I get a lawyer?
All right, thank you for that question. The first thing is I want to bust a myth. Legal isn't cheap. It's a myth. It's a myth because sometimes you might find out the price and say, oh well, it's not. And then it's not a question of legal isn't cheap. It's just where your priority is.
Mhm.
If I charge you maybe a 500K for a diagnostics now, you say, "Ah, that's too expensive. I want to use the money for something else." So it's not the money that is the issue. It's the fact that you believe that it's not priority. If you believe it was priority, you commit your resources to it. At what stage did I get a lawyer? At idea stage, because that idea you have may not may not fly, or there may be things you may need to. I mean, we had a one of somebody who assessed our diagnostic service. They were going to provide services for children, like it was a medical, it was a health tech. So they wanted to provide some services for children. So by the time we took them through and they saw that children consent, it was a bit complicated in that sense. So they just knew that okay, this idea we might need to like put it put it down a bit before we can, I mean, and leave it maybe to a later time because they saw it was slightly complicated getting the consent of children data protection and all those other things, so they knew that there was, I mean, they will need to do a lot. So it's at that stage that you need to involve a lawyer and you get a good lawyer. I mean, a startup lawyer who does technology. Let me give you an example. We had a client who they were seeking funding and then they had talked to the investors. And I'm going to confess to you, I believe that the reason why the investor decided to go on with that transaction was because we were involved. Because it's not, I'm talking about young boys. I'm talking about university undergraduates.
Mm.
And but they approached the investors when they gave us the term sheets. We looked at it, we made our own queries, we sent it to their lawyers. Their lawyers responded to us. We went back and forth, we had meetings. They knew that they were serious people. So, eventually they approved the funding for them. Now, they now wanted to, so it's time to pay, I mean, the funding. They told them they must get a specific bank. Their own bankers are the ones that are going to, they need a bank account. The bankers now said the CAC registration, this is an LTech. It was an LTech startup, but it had been set up like a medical. Someone who wanted to do like a hospital services, and the banker said, "Look, if you don't have doctors on your, I mean, as shareholders, we are not going to open an account for you because your objects are, medical services." And so it was the lawyer who registered it at the time, who did it like that. Rather than registering as a technology company, he registered it as a company to provide medical services. So you can see some, so now we are being delayed. We wanted to change the objects. CSC said we have to wait 28 days. So, and things can happen in 28 days. Your funding has been approved, but you're unable to get it because of a slight error by, the lawyer who registered it, who was just an ordinary lawyer. So talk to a startup lawyer, talk to them, get their rates. If it's something you can afford, pay it and get your diagnostics. At least prioritize that document. And then, you can now, afterwards, you can now start using your, whatever. I know you are bootstrapping, but like I said, you allocate your resources to what you think is important. If you think it is important, you allocate resources to it.
All right. Thank
So
you.
I think
That
idea
sounds
stages is where you should get a lawyer involved. I mean, a startup lawyer who does technology law.
interesting. Richard, so
Yes,
that
please. I might sound a little bit stubborn, yeah, but this is me talking as a founder. That sometimes, yeah, ideas and getting them off the ground are more of a priority to founders than legal. And I will explain why. Because the idea is, first time, let's say a founder that is just starting something as, let's say, 500, 1 million, even 2 million, he has scrapped from savings and even working overtime and all of the likes. And he wants to start a business. He already has the idea. Most likely, that founder will be thinking this part because I've thought like that before. Would be more of let me start. If there's any problem, we will sort it as we go. You understand? And that's the reality of most founders. We don't put money aside and be like, you know what, we'll allocate this amount to legal. No, I think the first time I drafted a document for from a legal perspective, I had to call my friend that was a lawyer. I had to explain what we're going through and I paid her, but that money was because I had already started something. You understand? So from our perspective as founders, legal can be something that's like you said, it's not expensive, but expensive is relative. So a
mm,
startup founder that is still the idea that's about to take off, we're not seeing the major reason for legalities when we think that we can always have a way to face whatever problem we have in the future by having enough money to hire the best lawyer. Do you understand that perspective? So most times we're stuck with that. So when, like you said it should be when we're about to start with the idea. But how can we create a balance with this concept? Because you are coming from a lawyer's perspective, we are coming from founder's perspective, and we're not having a common what is it called? We're not having a middle ground here. So how do we create this middle ground? I'm always looking for balance. So how do we create that middle ground? Because reality doesn't support the idea that a founder will be able to put aside some money when they are about to start a concept. They could do research online, read some documents online. So how do we create that balance? How do we have that middle ground?
All right, Richard, let me just add a layer to what you said. Titi, in reality, in fact, what we've seen on Umbrella is that some founders don't even have co-founder agreements. Eh? In fact, it's strange to some founders, right? And I get you when you say that's when a legal person comes into play. I agree with you, Titi, right? But again, some of these founders don't even have mentorship or advisory that points them in that direction. A lot of times, right? They've not even worked anywhere. The idea is burning in their heads. They have the technical experience, or they know somebody who is technical. They come together, they do the business together. Titi, in reality, I don't know, maybe in the abroad, right? Maybe they have startup lawyers, right? What I've also seen is some people play on buzzwords, right? So now you go and check, even if you're even saying go and look for a startup lawyer that understands tech. If you go on LinkedIn and you type startup lawyer, even the one that is in charge and bail has put startup lawyer there because he also understands that it seems like there's small money there. I will do it and I'll figure it out. Now, where is the place of using Chat GPT to even just draw out contracts at that very early stage? Titi, let's be realistic. I've seen it. In fact, I've seen some contract that comes from this thing, and you are surprised. You're like, this thing looks like something written by Chat GPT. All right. So let me let you have that. And then maybe we'll pause question for a bit and come to the next slide. Maybe some of your slides have answers for us. Maybe we shall allow you go because we want to chew you today. You are the legal person behind our problems.
Okay, all right. Let me just say, let me make a few comments. Mr. Richard has said that, well, as a startup founder, they prioritize, and I know that. I mean, I've been in this space. So, I mean, some of the things we even designed to ensure, to make things easier for startups, we have some things we designed to say, okay, look, so that it can be easier for you. A lot of times, sometimes startups don't take it. Mr. Ayola said, okay, maybe they don't have mentorship, but maybe it's not true because now I've said all these things I've said now. I've said, look, you need a diagnosis, you need to. But Mr. Richard is still telling me that, look, I know you have said I need it, but I'm not sure I do.
So you're saying
So
that founders
sometimes
are stubborn. That's what you're saying.
he already said he was
Yes, so
stubborn.
exactly.
So,
It will seem like I'm stubborn.
okay, no problem. No
Allegedly
problem. But all
stubborn.
I'm saying is that, you know, it depends on where your priority is as a startup founder. I told you about our clients. They are university boys. I'm not joking. They are university boys. And they started up and now they have funding. I mean, they have funding now, which is what we're trying to access by, amending their objects and all that. And why do I believe it's my own belief because the investors didn't tell us that was why they were funding them. But my belief is that they looked serious bringing in a lawyer into the transaction. They looked very serious. We question some of, so some of these, some investors, some startups don't question what is in the term sheet. The minute they say we are giving you $50,000, that's all they are hearing. They don't even care what they said. Whether they're going to get your mother's head and your grandma's leg, they don't mind. Just that we are getting that funding and that's all. But we told them, look, these are the things in the term sheets. Are you fine with this? Can you live with this and all that? So, but that back and forth, I believe, because it took a while for the investor to get back, but they eventually got back. And why would an investor go with undergraduates? I mean, there must be something they had seen that these are seriously minded business people. And that's the reason why they need. So you can say, okay, well, I don't think I need a lawyer. I'm trying to build something and all that. It's fine. I mean, you can decide that, okay, I'll bring a lawyer at MVP stage. But like I said, look at what happened to these people now. The lawyer that they got to do the registration had done, it wouldn't have mattered at that time. But at the time when they were going to access funding, was when that mistake now came up and is now delaying because 28 days is a long time. What if the investor changes his
That can
mind?
be a red flag for an investor, you know.
Exactly. So that's what I'm saying, that eventually everybody's going to choose what is important to them.
Mm.
You're going to have to choose what is important to you. So, and that's the reason for engagements like this, that, okay, look, these are the things you should do. These are the things you should do to avoid. And, as a startup founder, you can look at it and say, okay, well, I believe I should go this route and all that.
All
So
right.
I think so,
I
but I think, let me just try and maybe go through my slides. I know that, yeah, I know. I mean, these conversations are engaging and they answer the questions more, but we can also, generate more conversations from some of the things that we are going to also be saying.
All right, Titi, just before we go into your slides, so
Okay.
Michael Kolawole doesn't think that we're ignoring his message. He says, I'm playing in the media space, and my team and I often waylaid by security agents whenever we want to fly drones for certain events or clients, or even travel by air with them. I have checked, and I think that there is no law against drone ownership or having a license before we can fly. But my drone has been seized for 5 years, and subsequently drone works have been altered. What do I do? Michael, I think that you would speak to Titi in the deal room, because this is your own issue. We'll not solve it today.
Okay, okay. Michael, I'm going to drop my contact here, so you can speak to me later, and we can, and that's what, and unclear regulatory space is, I mean, is one of the challenges also with innovation.
Hmm.
Some things are unclear. So look at, for example, now this drone issue. Now it's an unclear space. Like you said, there's no regulation against it, but I'm sure the security man will say there's no regulation for it. So it's a two-way argument. But please feel free to contact me so that we can talk about that more. All right. So I mean, we're looking at founder armor must have legal documents as a startup.
Hmm.
Sorry, 1 minute. All right, so we're talking about the founders agreement, and Mr. Yola has said now that some founders don't have co-founders agreements; they don't have any agreements with themselves. And we gave an example of Snapchat and Brown. I want to believe that there was no, because that dispute cannot occur if there was a co-founders agreement. I want to believe, I might be wrong, but I'm thinking that there might not have been any co-founder agreement for them to have locked him out of, I mean, the entire thing, and he had to go to court, and then the court awarded him, I mean, I think about $159 million or something like that against Snapchat. So, but sometimes there's no founders agreement. As a matter of fact, sometimes the other person is not a co-founder. It's just somebody that you believe, okay, well, just come. Maybe you believe that investors would like to see a co-founder. Just, okay, come and be my co-founder. I'll give you 30% for doing nothing, for doing absolutely nothing. So, so there are different situations like that can occur, and the thing about when you bring on somebody that is doing nothing, after a while, you feel the burden because you are the one doing all the work, and they have, they are not doing anything, but you are the one, because maybe out of, trying to know what to do. You say, like, come and be my co-founder, and they are not finding anything. They are not finding anything. So those are some of the things that, so you can, I mean, outline roles, equity split, responsibilities, vesting. Vesting is very important. Okay, I'm going to give you 10%, but it's going to vest. So we are going to see your commitment before it vests. So those are little things that you can do to protect, I mean, and prevent future conflicts. We're talking about non-disclosure agreements. Some people, and this is a challenge, because I have startups who say to me, look, I want to pitch my idea to this person, and I don't know, they might take it. What do I do? And they are not going to sign an NDA. Those people want to give you money. Once you even bring an NDA today, they just say, please excuse me. So what do I do? I always tell, when I get to this point, I always say I have a personal solution to that, but I'm not going to disclose it. The trade secret. So, but so there are ways to go about it where you without you know without even going through that, or you can find a way to ensure that those things are binding on whoever you are disclosing your idea. IP assignments. Those of you who engage developers, they develop something fantastic for you, but there's no IP assignment, and then they just go and replicate it for someone else and all that. So those are some of the things you might say, oh, it will not happen to me, but what if it's a risk? What if it happens? So you need to protect against that. Shareholders agreement, employment agreement also. Your employment agreement must also be clear. They must define rules and responsibilities. You must have non-compete clause. Some people, their businesses are ruined by their employees who leave and go to join a competitor and divulges all their secrets to a competitor. So now you're telling me, oh, because I don't want to spend too much money. You are going to go and allow an employee take away your hard-earned, sweat and go and divulge it to other people. So those are some little things that you must pay attention to. So I said it prevents disputes, attracts investor confidence, and creates operational clarity. I've already given the Brown and Snapchat case study. Please, you can move on to the next slide. All right, so look at incorporation and structuring smart, choosing the right business structure. Yeah, that I'm sure a lot of people here are at idea stage. So there's the business name, there's the limited liability company, incorporated trust if you're an NGO and if you're a non-profit. So you must choose, one that is right. And there are also other business models. For example, I'm a company, Scott's Legal is a company, Umbrella is another company. We want to come together to do a business. We don't want to use Umbrella's name. We don't want to use Scott's Legal's name, but we want to collaborate. There are business vehicles you can use to carry out those that, and you won't have to use somebody's brand or the other person's brand and all that. So there are different kind of business models that you can use. So the third, incorporation matters because your protects your liability, your assets. If when you do a limited liability company, it protects your assets. There's what we call the personality are separate. The company is separate from the individual. So I can't sue Mr. Ayola. Even Umbrella is a limited company, I can't sue him personally for Umbrella's act. I have to sue Umbrella. So that's one of the reasons why you choose limited liability companies. And of course, it also allows you, it gives you credibility with investors. Some investors will not deal with you if you are doing a business name. So next slide. So we talk about, some want to also register like Delaware incorporations. If you're targeting global VC funding, you might need like a foreign registration. So because it's recognized in the US, as something, it attracts investors and VC funding. We also giving the health tech startup have given their case studies severally, and funding was altered due to incorporation error. So incorporation and structuring is very, very important. It might look like early stage. It might look like you could get a lawyer to just do something, but as a tech startup, you might need to consider what you're doing very well and take the right decisions. Next slide. So let's look at regulatory readiness. We have said that every startup has its own regulatory environment. We know that there are a lot of fintechs here, and I've already spoken about fintech. We're talking about CBN licensing, KYC, compliance, anti-money laundering obligations. For LTech, we are looking at NAFDAC and a Ministry of Health and some other certifications that you might need depending on what space. For Web3 blockchain, we're talking about SEC, and of course potential gray zones. We're looking at agri-tech, we're looking at export documentation, SON, Nesria, and some of the ed tech also. So don't ignore your regulator, and that's why I always advise the diagnostics. It allows you a good overview of your space and what you can do and what you cannot do.
All right.
So
let's quickly take Julius' question. I think Julius has a question. Julius, you can just mute yourself so that I don't want us to move past the slide and then he forgets his question. Or Julius, can you unmute yourself? while we're waiting for Julius to unmute himself, Richard, you can quickly go.
Okay, please, you said something about people not being able to hold the founders of the companies liable for certain things the company does. But I've realized that in Nigeria, the reverse is the case. If you have an issue with your company in situations like this, sometimes you see where people go and even go as far as garnishing the account of the founder of the company. And
That's
most
not
times,
I don't think that's the
so
situation.
exactly. Pardon?
okay. That's not possible. If
I've,
your
I've,
personal bank account is garnished, if your
I've
personal bank account is garnished, I can't hear you, sir.
Yes. So okay, can I should I give like a backstory? I know a company like a friend of mine owns a business. They ran into some murky waters, had some issues, and some of the people that are invested in the company started attacking the person personally. And the company was not even like it's not even just an LLC. I think it was listed were about to get approval on the Nigerian Stock Exchange. So it was even a PLC. And they were attacking the founder personally. So I've seen a situation like that. Like, is there a loophole in there where people can do things like that? Or I don't know. I'm just trying to understand because when you said that, I also resonate with it, and it happens in some cases where people would just start attacking, actually Nigerians. And one thing I've always said is Nigerian investors are not as matured as most in other countries. I don't know currently. Maybe we've had some upgrades, but most times we have those problems because of lack of maybe understanding of certain things. I don't know, but those kind of issues happen. Like, is there a loophole in the law that says they can do things like that, or it's just something that people do because they have the power to do it?
I now this is elementary law that you cannot come after the directors or shareholders of a company based on the debt or liability of a company. It's elementary law. I'm not sure what you're talking about, so maybe except I read the facts. In the case maybe you are, I mean, if it's a mortgage and you give a personal guarantee, maybe I'm not sure, but I don't think, I mean, elementary law, you can't come after, except it's a business name. If it's a business name, then the proprietors and the business are the same. If anything happens, they go after you personally. That's the reason why we discourage the use of business names. But if it's a company, nobody can go after your personal account. I mean, based on something that
I, I, I
the company
I
does.
wanted to even
So,
add that.
but I might need to read the facts of that case and maybe understand it before I can give a better opinion on that. But elementary law doesn't allow it.
So Titi, maybe
Okay.
a case of the founders using their like withdrawing money or doing stuff with their own accounts, then maybe that might have led to the founder being under such circumstance. But Julius, I don't know if you're back. It was because of you I quickly stopped the session. Um,
Yeah, thank you so much, thank you, Titi. I just want to ask a question in relation to the previous slide concerning the incorporation of companies here, most especially touching the Delaware incorporation here. So, yes, I'm aware that one is able to operate, in Nigeria. So far, you have your company incorporated in the country and all that. So my question is this, that if you have a Delaware incorporated company, and then you actually want, yes, I know basically for most people, they do that because they want to attract foreign funding or investment and all that. So if you do that and then you still want to operate in Nigeria landscape, would the founder still be required to incorporate a company in Nigeria to that effect? Because basically that the company, the main country of operation is let's say is Nigeria, but you went ahead to do a Delaware and incorporation. So would it be necessary again to have the company incorporated in Nigeria before one is able to operate, or how does that
Okay.
happen?
All right. Thank you for that question. All right. So it depends on what exactly it is you're doing. If you want to operate in Nigeria, the laws are that if you want to operate in a particular country, you must incorporate a company, I mean, in that country. So the reason why they do the Delaware angle is so that they use that company to deal with the foreign investors and VCs. So, but what usually happens is that sometimes it's either the Delaware company is the owner of the Nigerian company. How we get what I'm saying? You know, a company can own a company. So sometimes they link the two so that when they are talking to the investors, they say, look, we have this company also has the company in Nigeria and all that. So they usually link the two. So but if your business is focused on some businesses are not focused on Nigeria, they don't earn any income in Nigeria. We kind like that. They said, look, we don't have any targets. I mean, we have not come to Nigeria yet. Our our business doesn't it doesn't concern Nigeria. So you might not need to register any company in Nigeria. But if you are doing business, you are going to be earning an income as such in Nigeria. Of course, there are different things we can say to that. You know, so but if you're going to be earning an income in Nigeria and you're going to be doing business in Nigeria, you might need to register a Nigerian company, depending. So, because for example, now Uber, when they came in, they didn't register any company in Nigeria. It's an app. So, but they had a lot of back and forth with government on that issue because the government claimed that they were a transportation company. They said they're a technology company. So, but they had to eventually still do, government relations and license before they were allowed to operate. So sometimes, there's usually that thin line also. So, but it depends on what exactly you want to do. That's what is going to determine whether you need to incorporate in Delaware and also in Nigeria, or you can just do the Delaware, or you can just do the Nigeria.
All right.
All
Thank
right.
you.
Thank you.
Thank you. All right. So, well, we've also listed some key regulatory bodies that may affect some of the startups we find in the data here, and they are NIDA, deals with information technology, and the NDPC also. If you are processing data, you might need to also get NDPC compliance. If you are doing some government transactions, they ask for NDPC certifications, and you might need to provide that also. Next slide. All right. So, what do your investors want to see? What would they like to see? Because I know that a lot of people are particular about funding. So, what would the investors like to see? Valid incorporation documents, your CSC certificates, your MEMATs, your cap table also. Not you mustn't have. Allocated your shares in just all around there. Clear records of who owns what percentage. Your founders and shareholders agreements. They will want to see that would determine the roles and responsibilities of everyone. IP ownership, they want to know who owns the IPs. Regulatory licenses, if applicable, they want to know if you have the licenses, and your contract with your customers and employees, NDAs, employment letters, service agreements. Some of the things those are some of the things that your investors are going to, when they are doing due diligence, they have like a long list of things that they are going to ask you. So eventually you are going to come back. You are still going to come back to, to some of these things so that you can satisfy them. Red flags for investors: conflicting co-founder claims. I'm the one that I own this. I don't own this. That are some of the red flags. So I know that some investors also registered for this event. So so as an investor, some of the things you can look out for are conflicting co-founder claims. You should already be wary when you see things like that. Dispute over roles, shares, or control. That also might be a red flag that you might need to watch. Unclear IP ownership, because it might come back. If the IP ownership is not clear. Products built without IP assignments from developers. That might be also a red flag, because developers can come later, to start making trouble. Unregistered business or invalid filings. Incorrect regulatory filings. If you have a license and it has expired, that also might be a red flag. Hidden liabilities or unresolved legal disputes, and also pending lawsuits might also be. Unreported debts, tax issues might also be red flags for investors. Next slide.
All right.
All right. So the VC wants structure, a functional board. I think somebody mentioned here that Nigerians don't usually, they don't get the director game very well, and that's the truth. We just operate from our rooms, and we don't even know what a board of director is. And that's why I said at the earlier stage that a business is a legal creation. So yeah, it's right there in your CSC. We have 2 directors, we have 3 directors, but they're not, they don't really do anything, which is not bad. It's just that, when you are now seeking corporate funding, you might need to start looking at things like that. A functional board, documented minutes and resolutions, your financials, KPIs, decision-making frameworks and clarity. And also, so you keep your data room updated with some of these things that we have listed here. All right.
All right.
Next
So
slide.
yeah, I have a question.
Go ahead, sir.
Um, and it goes to the board, right? So you're trying to put a board together. Oftentimes, what's the best approach? Because I've seen founders um just look at, I think this person is good for my business, or this person's image is good for my business. And I know there's executive board and non-executive board members and all that. Do what do you do at that stage as a founder trying to put a board together?
Well, the truth about it is that it depends on what stage you are. When we talk about maybe composing like a proper board of directors, we are talking about maybe growth stage,
Okay.
maybe seed stage or growth stage. Because at your early stage, you don't want to be bogged down with a board of director issues, because you're still building your product, and you want less issues at that point. So because when we're talking about a board of direction, we're not talking about like structure, like people who can now say no to your decisions. And if you're familiar with boardroom politics, it's not usually very funny. Now I've had to sit on boards, and the politics is crazy. Somebody wants to block you, somebody doesn't want you to do something, somebody wants to do something, it's usually a bit, crazy. So at the earliest stage, I mean, we had a particular, and that's why, Mr. Yola asked a question about ChatGPT. Some of these founders who use ChatGPT, when you see them, you just laugh. So, you have used ChatGPT, and they have told you that you need to maybe compose a board, and then you have a board of directors, this person, this, and then decision making become extremely difficult. I've had several startups who have to complain that, look, these people are just difficult. We can't even move on. They're not even allowing us to move on. And these are people that brought, how much did they give it to the business? Maybe 1 million, 2 million. And then they become members of the board of directors, and they are just being extremely difficult. So sometimes, I mean, some of those, things you get from ChatGPT. Yes, ChatGPT is extremely intelligent. I use it, although I will never use a ChatGPT argument without properly, looking through it. And because a lot of sometimes they say it says things that you are wondering, where is intelligence in this? That as a lawyer, I'm talking about a lawyer. So some people rely on it, but you can't rely on it, because there are a lot of things that happen in practice that are different from the ideal. And it might just be giving you an ideal that may not work in practice. So when it comes to the board, you can leave it to a stage where you now want to put accountability structure, things that will allow that business, scale to, I mean,
The next
scale
level.
further. You can now have, the director. But at the earliest stage, CSC allows you to register with only one director. You can take that window, only one director, so you can make all the decisions yourself and all that. So you see some even bringing in their developers and their marketers as co-founders. A lot of things just happen that eventually those things, they boomerang and affect what you are doing.
So
So
quickly, I think that these things have also germinated from maybe the Silicon Valley model, where if you're a solo founder, and the investor, sometimes you find out that investors are not even willing to invest because you're a solo founder. Hence, founders are forced to, work with a second person, right? Or look for a second person, or look for someone to work with, right? Hence, maybe the engineer that they could have just paid, now becomes a co-founder, right? And so I see that also happening. What's your take on that? And then shortly after that, then Faithful can also go.
all right. Okay. So, well, yeah. I do agree that some of the things that are being replicated are, models that have been passed. So, and there might not even be anything wrong with having that developer or whoever as your co-founder, but it must be clearly stated what their roles and responsibility are, what they are bringing to the table, and how much. I mean, you don't just give out your equity as though just okay, yeah, co-founder 40%. No, it has to be clearly stated. You know what exactly they are doing, and so there might not be anything wrong with having a co-founder as such, but how is it structured so that the person knows what his position is in the company. He knows that okay, this is what I have. This is, and of course, yes, you have to make it attractive enough for them, but then you have to also look at, I mean, what they are bringing to the table and what is the worth and the value of what they're bringing to the table. So there might not be anything wrong with that model to have a co-founder. If I mean, and that's why at early stage people usually rely on family and friends rounds and all that. And you can also make those things formal. We have clients who his family and friend rounds, it's with a term sheet, he sends it to them. I mean, it's serious. It makes it serious. So the fact that you are raising, if I mean, family and friends round doesn't mean you have to just go cap in hand to, yes, you might have to do that sometimes, to some of, I mean, your very close relatives and all that. But sometimes your family and friend round can be really, really formal, and they know that you are a serious person. So so you can you use that for your early stage and all that. So, but by the time you are now graduating to maybe pre-seed, seed, and all that, you can now start put in some structures. That's why, like I said, the diagnostics helps you to say, okay, at this stage, I don't need much. I need only this. But by the time I'm moving to this, I must start considering this and this and this.
All right. Thank you. Faithful.
Okay, hi, good morning, everybody. So the first question I have is, first of all, does your board of director has to be a shareholder in the company? That's the first question. And is it really necessary in terms of seeking investors? Just like you said, the CEC allows you to be the sole director, the sole board of directors, and of course the sole director, but you require at least two directors to have a board of director. So how important is the board of director? Is it really that important when seeking investors?
Okay, all right. Thank you. I think, like I said, and I think I certainly answered that question. When it comes to it depends on the stage you are in. If it's an early stage startup and you're not seeking like real corporate funding, I mean, like VC funding and all that, if at that stage you can still make do with, so that it allows for easy decision making when there's only one, but I mean one director, and you can make all the decisions yourself and put things the way you want it to be. But when you now start moving up, to some stages, then you might now have to start putting some structures in place. You asked a question that I'm trying to remember now. So, but the board of director it's a structure. It allows you to put structure. That means you are not like Mr. Yola said. You are not working alone. You now have some kind of structure. And in any event, in a lot of the term sheets from the investors, they would want to appoint a director. So they say a minimum of three directors, two to the founders and one to them. So a lot of times, by the time you are now looking at investor funding, I mean like corporate funding, they are already looking at um, a board of director. So you ask the question whether the board of directors have to be the shareholders. No, they don't. The shareholders can be different from the directors. Shareholders are those who own the company. A director doesn't have to own the company. A director is like, I don't say an employee in that sense, but it's like an officer of the company that runs the daily affairs. That's executive directors. Non-EDs are those, they don't run, but they're there to provide advisory roles and all that. So I mean, the director does not have to be a shareholder. You can have directors who are not shareholders, but they are executive directors. They participate in the day-to-day running of the company. So, but those are, and that's why some companies last and some don't last. If those structures allow companies to last, that's why if you're building something that will outlast you, not just something that you just want to use for a time and then move on to something else, but if you're building something that will last, so those structures come at a particular stage of the startup. Doesn't necessarily need to come at the earliest stage of the startup.
All right. Titi, and there's a question for you. Sorry, Faithful, you want to speak?
Okay, so which means, in short, the board of directors will be important when the company scales bigger in terms of bigger funding and a more scaled, a more larger scale uh, s- um, process. So the question is that how can we maintain ownership? Because I've been doing some of my research and I found out that uh, board of directors most times call the shots. And I had an issue. There was a time I was trying to get a co-founder, and he wasn't really investing much, but he was ready. And I noticed something. He was prioritizing us creating a smaller, cheaper games that we can put in a lot of ads and make some money. And I told him that's not the model we're going for. We're going for an authentic, story-driven, immersive games, which is very expensive to make, to be honest. But that is what we want. Yeah, these cheaper games takes shorter times to make, and the revenue might be very small. But I don't want to spoil the brand with those kind of games. And I had to like decline the offer at some point because it was really investing more on us creating smaller and cheaper games. So in that light, how is there a way, is there like a legal way to maintain this main decision that act the company, that like decide where the company is going towards?
Okay, so
Okay. So when it
just
comes to decision making,
for some background,
okay,
I think
all
Faithful
right,
is in the gaming industry.
okay,
So I think that's where his question is coming from.
all right. Thank
Yeah.
you, Mr. Faithful. And when it comes to decision making, so these are some of the things that you also need to pay attention to. Because for example, in co-founders agreements there must be a clause on decision making. Decision making lies solely with founder A. Decision making is 60-40, is 70-30. Those must be clearly defined. And so that means that if it's maybe 80-10, 80-20, that means the person has a say but does not have a right to the final decisions made. So when it comes to the board of directors, like I said, there are some companies that, as they are starting out, they are starting with a board of director. If we are looking at maybe like something in the FCMG, or a construction company and all that, those ones they have money, they are already. But we're looking at startups. As a startup, it might not be too advisable at that point to start with a board of directors, because again, like you said, it has to do with decision making. So you can start with one director, which is yourself, where you make the decisions for the startup at the early stage, and as you are scaling, you now introduce more directors when you believe that you are at that point, and you can always be able to get expert opinion whether you're at the point where you can take in, where you can expand and have with that with a board of directors, you look attractive to investors because they believe that you know what you're doing. With the caliber of people on your board, I mean, doesn't necessarily have to be go and invite people that don't have time. I'm not saying that, just people that you have on your board, you can, it will be something attractive to investors. But before you get to that stage, it's to aid easy decision making. It might be good to start lean. You know, what we're talking about, you might have started with a friend. Maybe it's a startup that is actually co-founded, and both of you are directors. Like the health tech startup I said, there are two of them, and both of them are directors. So there's nothing wrong with that. If it's a startup that is actually co-founded, both of you have the idea and you're both driving it. So you can have to, and even if it's three people, it's a three people idea, and three of you are driving it equally. Three of you can be directors already. Do you know what I'm saying? So, there's no other fast rule. Just you look at what exactly you're doing and to be able to know what exactly to do. Somebody was talking about the advisory board. Yes, you can have an advisory. We have clients who have advisory board without the board of directors. Yeah, if they, but the thing is that people usually choose these really high up people. Yeah, because of the value they believe they can bring. But a lot of times, those people don't have any time. They don't have time for your startup. That's the frank truth. So, but yes, you can have an advisory board if you believe that there are people that you can get their attention and they can advise you without being on your board of directors.
Let me ask you a question. Should advisory get equity?
What?
Should your advisors get equity in your business?
Well, that's a business decision, not a legal advice. Because I'm an advisor, and I know I have um, equity on some of the startups that you know. So that's a business decision. It's not.
That the
I
founder should
mean,
take,
it's
right?
not a.
A
It's
business
not illegal.
a
What?
business decision that the
It's a
founder.
business decision that the founder should take. That okay, what's the value they are bringing? If they're bringing enough value, or you need that service, you need the advisory, and but you are unable to pay for it, you can get into such arrangements, and it might benefit you at the end of the day if they're going to work and bring in their expertise without charging you for it. So that works for you, So that's a business decision solely.
And this doesn't affect the cap table because somewhere in your slide you spoke about keeping the cap table clean, right? Um, so you it doesn't also affect the cap table.
No,
This
it doesn't affect your cap table because, for example, this startup I was talking about, and when we had to do the cap table, it was just a simple thing. I'm sure the investor also understands that but of course you don't give out like 50%, 100%, and things like that. That's what usually ticks people off. If you negotiated it, just a slight percentage for their services, there's absolutely nothing wrong with that.
all right, thank you. I don't know if there are other questions so that we can move on. Titi, you can actually move on. I've changed the slide.
I'm not sure. Okay, all right. So I'm not sure. Well, I still have so many things today, but I think I'm not going to go over them. Yeah, and I'm glad we had conversations here and there, and I hope that we can take the conversations further. Okay, somebody is asking what percentage is advisable to be apportioned to members of the advisory board. Well, um, again, that's a business decision. So, but you can, depend on what you are building, you can keep it. Some ideas, you already know it's a big idea. Even the advisors know. And you can say 2%, 3%, 4%, depending. You can already see it's a big idea. Some ideas here, they're fine. Maybe thinking 10% or 5%, depending on what exactly they're doing for you. So, you know, somebody says, oh, this is not as important as legal. I hope this is not just on paper. I hope this is for real. Okay. So yeah, so it depends on what they are bringing to the table. If they're bringing a lot to the table, and they're demanding whatever it is they're demanding, you can say, okay, well, um, yes, you can negotiate with them and say, okay, well, but I don't think you should be going to 30% or 20% for an advisor. But again, it's a business. It's not a legal decision. You can find an advisor that is bringing in something worth up to that.
So, so,
So,
so
yeah.
Titi, should this also come with like a vesting period, you know, um, before the advisor can, maybe start to get anything from you, at least a vesting period? And
From my experience,
Titi, sorry,
from my experience,
no, I know that you want to go into it, but we're speaking legal armor for startups, right? So as open as you can be to us, please be, because I've been hearing you now say it's a business advice, it's a business. You're supposed to give us the armor to go to war, you know?
okay. Well, like I said, the truth about it is that some things are legal decisions, some things are business decisions. Okay. Of course, maybe I'm an advisor, so that might also, I'm an advisor and I do negotiate with startups on. So like I said, it's a business decision but you just asked me something now.
Yeah.
What did you ask?
Oh, I was just saying that should there be vesting period for this?
Okay, for an advisor. Well, from my experience, because the advisor is bringing something to the table, they might not concede to a vesting period, but again, it's based on your negotiation. From my little experience, I haven't seen an advisor allocation being subject to vesting period. Not because it can't be, but because maybe it was not negotiated or it wasn't thought about and all that. So, but you can negotiate a vesting period so that at least you can keep them also committed to your
Okay.
to your business, and they don't just take that equity and not provide the service. In any event, the service they are supposed to provide would already be clearly stated in whatever agreements you both of you have. So you can always, tell them that okay, and you can always make it. You can always tie it to to their deliverables.
So Titi, there are questions for you in the chat, right? I don't know.
Okay.
So, is equity sharing a legal decision or a business decision?
To share your equity, it can be legal and it can be a business decision. Now, because like I said, it depends on what the person is bringing to the table. I've been in discussions, business discussions, and somebody says, "Look, I'm not taking anything less than 50%. I don't do business with anything less than 50%." And you are there like, okay, so now yeah, well, a liar can advise you and say, "Look, 50% means you have equal rights. You have, but you look at what the person is bringing. Maybe they want to give you maybe 100 million naira. And you're like, well, at this stage, I need to collect this money, So, but you can collect it knowing the implications of your decision. And that's how illegal come in. They say, okay, look, this is the implication of this decision. This is what you can, but this is what you can do and all that. So it's illegal and it's also a business decision. So sometimes you can negotiate. Sometimes a lot of investors don't take more than 10% and all that. They don't take more than that. But some investors can come and say, okay, this is what we're going to take. You look at what they're bringing and say, oh, this money they're bringing is just small money. And if I allocate to them this equity they're asking for, that's like selling off my idea. You might decline it. So, and then look to others.
All right, Titi,
But so it's both
let me,
ways.
let me jump in there. Let me just paint a scenario. I have a friend. We're going into business together as a founder, but I don't want to have that difficult conversation, right? I don't want to. I want him to we want to have a co-founder agreement on equity and all those things, but I don't want to negotiate. I want to play good cop, and then I want my lawyer or my legal person to play bad cop. Where I've told the lawyer, I agree, I don't want to tell him he has 10% equity because he might look at it that we thought that we sat down together, I fine-tuned your ideas for you, and then we're about to do the business together. Now you're telling me that you get all the equity and then you're giving me just 10%. How should founders navigate these very difficult conversations around equity sharing with co-founders? Because it's actually a difficult conversation.
Okay. The way I know to do, yeah, like I said, I've been a lawyer for 18 years. The way I know to do agreements is to sit down in a room and a meeting with, the business owners and a lawyer, then have a checklist and then start the discussion. So usually we will have those meetings, long meetings, like they'll take like a whole day. Then we'll now take each item on the checklist. So what is this? Then somebody will say, okay, this is this. Another person will respond and say no. But they will go back and forth, argue, then arrive at a conclusion at the end of the day. Or some they say, look, let's pend it till a later time until we can find. So and the lawyer too can advise and say, okay, well, if you do it this way, this is because the lawyer is sitting in the meeting. That's how I know to do agreements. It's these days that you just come up with a ChatGPT agreement and send it to someone, and then the person just look at it, and then eventually something happens. So, but the way I know to do agreements is that we all sit down. So in that kind of instance, we say, okay, well, we have a lawyer, so I think we should have a meeting to discuss the details. So we have a checklist of things that we need to fine tune, and then we take the items one after the other and discuss because you can't avoid that discussion. You can't. Also, of course, maybe with the presence of the lawyer there, it can also aid because they can advise and all that. So, but what I'm saying now, they can have their own lawyer, you can have your own lawyer, and all of you sit together and then talk around and then agree on some of those points. So you don't need to be shy to talk about these things. You have to, because if you're going to do business together, you have to be able to speak about some of those things. So that's how I think is a very good way to do some of those things. Just have a checklist. It's okay. Let's talk about the name of the business. Okay, well, name. Yeah, I suggest this is this. I suggest this. I don't think this is okay, but how about this? Okay, let's agree on this. Let's agree on this too. Whichever one, CAC, okay. Let's talk about your responsibilities. Okay, man, I'm going to be doing this. Well, what you're doing, I don't think is going to be, it's not good enough. I mean, you can also provide, you talk, and then the lawyer documents your agreement on each point, and then they can go and come up with an agreement from that. So that's the way I know to do it.
All right, thank you. I think you can come back to your slides. So more questions coming.
Okay. All right. Yeah, so we put some legal traps that can happen at each stage, at idea stage, sharing ideas without NDAs. There can be IP theft, and IP theft is real. And I mean, let me just like practical IP thefts. This is not even founding them. I mean, have you seen instances where somebody goes to a club to sing a song, and then maybe one of these big boys are there and then you hear the song, and then before you know it, the song is, they have gone to record it. I mean, I've seen that instance before. They go to record it and it becomes a music. I mean, it's something that is very popular, and the other guy say, no, this was my song, I sang it in this club, blah 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 blah. So sometimes when you start ideas without NDAs, it might lead to IP theft. I usually give one case study here. TV is TV Extra and NUC, Nigerian University Commission. So TV Extra went to Nigerian University Commission. Okay, I have a bit of a challenge now. I have another meeting for 11:30.
All right, we can quickly do a hard stop in 10 minutes if you can grant us 10 minutes of your time. Or maybe can also take over.
Okay, maybe Dumebi can take over. Dumebi, are you there? So, but let me finish this case study. So,
Yes, ma'am.
so she, okay, all right. I'll hand over to you now. You can continue from my slides. So, TV Extra, they had this university debate, a debate idea, debate between universities. So they went to pitch it to Nigerian University Commission, and they just discarded them. You know how they just said, "Ah, we are not interested." And not long after that, Zain Nigeria, and I'm not sure if you remember that university challenge they used to have then with Nigerian University Commission, now went to do the idea, I mean, on TV. And then TV Extra said, no, this was our idea. We pitched it to you. And all that. So sometimes when you pitch your ideas without NDA, it's like hour maybe to take over while I quickly have my meeting.
All right, maybe over to you.
Okay. Good morning, everyone. My name is Dumebi. So I'll just take up from, I believe, the pre-seed stage. I'm sorry, I'm sure I'm not going to be as jovial as Miss Titi was, because I was not expecting to just hop in here, but you bear with me. Okay, so on the pre-seed stage, this is the stage where you are basically accepting funds from your family and friends, right? And there are some things that can happen in that stage, right? Where you just go and you just take money from someone without a similar thing that happened with Snapchat, Brown versus Snap. They were friends and they came up with the idea together, but the Reggie Brown was never involved in it was his idea, basically. The whole Snapchat disappearing feature, everything was his idea. And he shared the idea with his friends, his pals, and obviously we all know Snapchat, so the idea took off. And later on he came back to say that, look, you have to acknowledge me as a co-founder, you have to acknowledge me that this is my idea and all of that. Well, they were magnanimous enough to actually do that, and he was paid a very hefty amount and also acknowledged as a co-founder. Of course, this could have been avoided if there was any form of agreement, because intellectual property is just what it is, intellectual property, meaning that even if the person did not stricto sense to say, oh, this is an agreement, or this is my copyrighted source code, or whatever, the person shared an idea with you, and that idea is still that person's intellectual property. So I believe it's also a very serious legal trap that people tend to fall into when you also sign contracts without properly reviewing it, or borrowing code or IP. Again, that's a similar thing to, I think, the example with Snapchat, right? Where, for example, I think I'm going to merge these last 2 points and just give a rough example of, you tell a software developer, okay, build this product for me. I have this idea, this is the product, I want you to build it, right? And then the person does that. And in all of the building and all of that, there's no software agreement, or there's a software agreement and there's no IP assignment clause in that agreement. You can run into an issue if you just happen to you're unfortunate to have a very, like, call it, greedy, software developer who just comes later on and says, well, it's still my code, it's still my ideas and it's still my code, rather. I'm the one that built it and all of that, and it has not been assigned to you and all of that. And then they can come and say, oh, well, we want to be claiming, maybe royalties off of every sale, every app sale, that can also happen. And it could usually happen at the pre-seed stage, right? That's just before you go into getting actual seed. Okay, seed stage as well. Some legal traps that can happen or it can fall into is where you fail to register your trademarks, where you hire without employment contract, and when you miss regulatory licenses, right? And I think the regulatory licenses, Ms. Titi covered that already with Paystack. The Paystack issue, I think right now they're facing fines from the CBN. So I believe I guess I don't have to cover so much on the trademarks issue. I don't know if we should know the importance of trademarks as business owners. I'm very sure we heard of the
Zap.
Paystacks. Yes, Zap versus Zap Africa. It was a similar, and both of them were claiming, oh, that I've registered my trademark. The other one who said I've registered my trademark. A lot of people don't know that, there are actually different classes under trademark registration. So you can register in one class thinking that's the only class that will affect you, and then somebody else goes and registers in another class that's similar enough, and then you see the same name and you're wondering why. Our advice usually would be, when we do a diagnosis, we'll look at all the classes that your brand ought to be registered under, and our advice, our counsel, will usually be to trademark under each of those classes, because I'm sure people like Paystack now, just imagine going up against the Paystack, right, in terms of a trademark battle. So that's already an issue on its own. So it's obviously advisable that before you launch, before you put out your brand, that you actually trademark in all the classes that are relevant to your brand, right? So the growth stage, failing to update company filings or board structures, this falls under corporate governance. Ignoring data protection laws, of course, the NDPA is very strict now with that. And then, lack of standard contracts with clients and vendors. So these are some similar trap, or some, what I call it, familiar now, traps that I see personally when I engage with startups that are in their growth stage, right? Some of them fail to do simple things like, filing annual returns regularly, or just complying with corporate governance structures and the code of corporate governance. Even ignoring data protection. The NDPA is very clear, and they've become very strict since the what's it called, since they passed the act, right? So as the data processor, there are some things that you must be aware of. Some people say, oh, but I'm not processing so much data. I'm only doing 1,000 data, or I'm not using the data for anything. The government, it's not really, let's say it's not their concern. What the law states is that if you're a data processor, you must register with the NDPA. And having done that, depending on the amount of data that you actually process, say you process, maybe you're a fintech, for example, look at the information you'll be collecting from clients. You'll be collecting their names, their what else? Their names, gender, date of birth, next of kin in some cases, bank details, BVN, NIN. Those are very, very private, information about people, and you'll be processing such information on a day-to-day in their numbers, right? You are expected to have an audit in place, have a DPO, your DP data protection officer must also be in place. You must do your annual filings and annual auditings with the NDP. These what will I call it? These regulatory nuances are actually very important, because if there's ever, for example, God forbid, a breach, right, and there's just maybe a hack or something, and the government, because the government will know about it, because you must also report it. That's also part of the regulatory nuances. And they find out, and then they come to see that you're actually not, there's no, I think there's a prison, what's it called? Prison, what do I call it now? There are fines attached to it, and also there's a sentencing as well attached to it. That means they've made it a criminal offense, right? So those are things that you must also take very, like, call it, take
Very serious.
close attention to. Yeah, I think the next slide.
All right. So, Titi, sorry, maybe before you move forward, there's a question that I wanted to ask around this, right? What we presented. I see that at what stage should you even do the trademarking, right? That's the first question I have for you, right? Is it at the stage of ideas where my idea is this? At what stage should I do that? I also see some investor related forms where they ask, like, do you have any patents? Do you have any patents? Or do you have any trademark, of the product itself? So I just want you to just make some clarity to the founders on this call around those two things and why they are important to have them, moving forward. And this is at even pre-seed stage, or
Okay, so most advisable is that you get your trademark. The moment you think of the name and you're certain, okay, I want to get the name, before you go ahead to go and get your domain, because that's usually, that's usually the next step. Just like, I'm going to go and get my domain. I already have my domain. Yes, your domain actually will not be relevant if that name belongs to somebody else already. In fact, you can be imposing on someone else's IP, and they can serve you a cease and desist letter. So it's not the moment you think of the name, okay, I want to name the product this, right? This is the name I want to give the product. Before you think of building the app, in fact, app should not even be, if you're even thinking of the app, if you've not even trademarked the name, before you even think of buying the domain, you must run a trademark search, find out if that name is available in that class, right? So basically, the moment you think of the name, even if it was given to you, there's people that will say things like, "Oh, this name was given to me in my dream," and I say, "I'm so sorry about that." So it
so
doesn't matter how you got the name, just go and trademark it, because your dream and whoever gave it to you in the dream, also needs to know that there's a trademark registry, and people also have dreams too. Well, yes, I say that as a joke because I've actually heard, someone actually say that. It was like, no, nobody can ever have this name, and he ended up having to rebrand. So
so
I, I, I don't think it's wise. I know people hear, oh, it's expensive, and then they fail to do it. Rebranding is much more expensive, in my own opinion. So
word,
yes,
word. All right. So I think my follow-up question, Faithful, I see your hands up, and it's been long up for the longest. Is that what if you want to use that name and it's been trademarked by somebody else, but you guys are not in the same, you're not doing the same thing. And you still trademark?
it's again, like I said, it's in classes, right?
Okay.
If, for example, Zap was a footwear brand, right? And Paystack Zap comes out and says they're a fintech brand, there will be no disputes. And if anybody tries to, the only thing they can try to do is maybe cause some noise because of publicity, but they are not in the same class of, they're not in the same brand class. But the reason why this Zap versus Zap Africa was an issue is because they are doing similar things. They are in a similar space. Yeah, I think one is of the blockchain side, and one was, but fintech is still. Do you understand? It's still categorizes under financial services in a way because there's no crypto class. So it's still going to fall under financial services, right? There's also business services class. There's technology class. So let's say, for example, someone called, Dumebi brand, and the person is a shoe person. And then there's another person, Dumebi brand, and the person does food, right? If you don't want anybody, if you are the first person that has that name and you're like, you know what, I know someone that has trademarked in all the classes. I mean, all 46 or so, 46 classes.
Wow.
A lot of money. But the person just decided, you know what, I don't want anybody from anywhere in any town, to just decide that, okay, they want to start with a similar name. So the person went ahead and trademarked all 45 or 46 classes. It was very costly, but I mean, the person knows where he's going. And he had already said, oh, I plan to be, and he knew where he was going, so he didn't mind footing that expense. So it's really, yeah. I don't know if I answered your question.
You did. You actually did. Let's have Faithful. Faithful, your hands are up.
Okay, I just have one small question. You mentioned about your due diligence for anniversary contract employment for your staffs and all of that. So, as a startup here at SA Games, we paying a lot of people. So I came up with a way. ChatGPT was a friend that actually helped a lot. So we do more of a contract partnership agreement where people work with us and we pay them very small money, which is not even up to the standard of salaries. And in return, we give them royalties on the project they're working on. So is that like a legal structure? Does that works well? And would that sit well with investors when they want to come in, saying that, okay, we don't have actual staffs, but rather we have partners that we pay them monthly stipends and in return we give them royalties on what they're working on?
Okay, so this is usually where there's a bit of an issue. So what do you classify them as? Are they freelancers? Or what are they?
In the contract, I classify them as partners, in the independent contractors. Sorry, I classify them in the contract is independent contractors.
Okay, so they are independent contractors. Do you have a royalty agreement with them?
Yes, the royalty is also part of the contract. So there's a percentage in there as well.
Okay, that can work, but to just make it neater, this is just me because you have to put together your data room, your legal data room, right? This is just me, right? It can be a different opinion for someone else, but if I'm looking at your data room and you're telling me you have this person and you're paying royalties to these people and they're independent contractors, the question is why, for how long, and there must be a separate agreement, that actually speaks to the royalties. I don't know if you know that, because if you just lump it up with an independent, yes, person is an independent contractor, fine. An independent contractor should be paid independently. So why is the person's money now tied to your royalties? Why is it tied to the product of the company if the person is an independent contractor?
Okay.
All right. So Faithful, maybe
So,
you need to
okay.
contact maybe Scott Legals after this. There's a deal room that would open soon. Maybe in the deal room you can get like deeper insight into their approach. You've been on the calls, right? So you know how the deal rooms work.
Yeah.
So maybe you just
Actually came a bit late today, but yeah.
yeah, so maybe you do that. Let's have Vincent. Vincent, I see your hands are up. And then I'll just read what the things in the chat for the maybe.
Yeah.
All
Bring that
right.
white cement. Put down for that small buckets. No, this is
All right,
for
Faithful.
this.
I'm going to
Can you
mute.
hear me?
Yeah, Vincent, you
Okay.
can go.
All right. Thank you very much. I think the conversation has really been very, very brilliant. Very, very brilliant, right? And I'm learning a lot. So what I wanted to ask is around trademark, mostly, especially a trademark conversation. Okay, I think my first question is at what point of your startup journey do you start bringing in a lawyer? Maybe even if you're a solo founder, right? And maybe there won't be a lot of contract, partnership contract or co-founder contract and all of that. You're just a solo founder. At what point in that journey do you bring in a lawyer? And then secondly, which is actually the most important for me, is around conversion of trademark, right? So, if I trademark for, how do I, let's say, do you trademark around geography, for example, say, my trademark, say, hold on for me, please, sorry. I'll call you.
All right, Richard, let's have you. Richard, let's have you while Vincent comes back.
Okay. Please, my own question concerning trademark is, can your registration of the company be approved? For instance, let's say there's someone that after your business has been working for a while, someone took that name and went to trademark it, and now you have an issue that you have to prove that this business has been in existence before the trademark. Is this something you can do to say, okay, we were here before these people, they saw this name, and that's why they decided to go and trademark it at this particular time? Is it like a proof for you to fight for that trademark?
Okay, so I'm back now. I can just quickly wrap up with my question. So my question is, so I'm building let's say a media platform, right? A Pan-African media publication, right? And it has a continent name in it. Let's say Right Asia, for example. I'm just using that as an example. Say Right Asia or XYZ America. That is the name of the publication. So when you have that kind of name in your that kind of nomenclature in your naming, America, Asia, or Africa, or something, right? Two words. How do you go about? Because it's somehow it's somewhat generic, right? So how do you trademark that? I think that's my question.
Okay, to maybe over to you. I don't know if you had all the three questions.
I didn't get, I think Mr. Richard's own, I didn't get it so well. But let me just answer this first one.
Okay, so let me recap Richard's own. He said that he has a trademark, but let's assume that he's gone out and then someone has has done the trademark before his business does it. But his business has been in operation much earlier before then. Can he fight for the trademark since there's evidence that the business has been there before the person that did the trademark?
Well, yes, but I don't know. The chances of okay, let's say you do a cease and desist letter to the person. The question the court will ask you is, okay, you've been in existence for longer than, why then didn't you trademark, right? So it's a yes, and it can also be a no. I can say it's a yes because, okay, if you have the money, why not? If you say, oh, I've been existing before Coca-Cola and Coca-Cola stole my name, we'll help you because, I mean, look at the brand, right? And that's if you are ready to fight the fight because it's financial. It has a lot of financial implications. So it's yes and can also be no. So in the larger part of it is that, okay, the jurisprudence behind it is just do your trademark when you ought to. So you don't have to start saying who came first. The person that you're thinking the person came after you. The person can just come up with one document from 20 years ago and say, look at where I got the name from, and I've been here since. So you think you actually came before the person, maybe because now the person has launched. Again, you can find out when the person trademarked by just running a search. You can find out the year that it was trademarked. So you can now say, okay, well, you know whether you should bow out or if you still want to go ahead and fight. And if they are not in the same class with you, I don't see the point. Yeah.
All right. So Vincent's question is that, can he trademark a name with like a country attached or a continent attached to it? And at what stage should you even get a legal person if you are a solo founder? Titi is back, but maybe I want you to do justice to this. The whole Scott legal as an entity is very interesting, and I love that you people bring a lot of wealth to the table. So I want people to know that if they don't get Titi, if they may be speaking to you, be sure that you have 100%.
Thank you, sir. So like he had already kind of answered his own question. when he said, the word, there are names that are not, you can't trademark them. Like I said, whether it was given to you in a dream or not, you cannot trademark Africa. You cannot trademark Nigeria. So if it's a part of your name, you have to take it out and trademark what is actually relevant to you. In fact, there are some names now that the trademark registry are now rejecting. For example, you can't trademark the word gold. And then some people now come up with, maybe the Greek word for gold. And then they say, oh, this is my trademark. And then the trademark registry will just do some search and they'll say, nope, that this is another language, but the word means gold, right? And they'll say, no, you cannot trademark gold. So there's a way sometimes we're able to get through that hurdle, but sometimes we're not able to get past through that hurdle, basically. So it's generic names, generic words as a part of your trademark name, it won't be trademarked. However, if you have your maybe like a name before that, maybe let's say Dumebi Africa, you can trademark Dumebi without the Africa, but you can still use the Dumebi Africa as your brand name, right? It's just that you know that the actual trademark, registered trademark, is the word Dumebi. I don't know if that's clear.
So it seems like you're even talking to us. We tried to do a trademark for umbrella. It never got anywhere. So what we did was to put the prefix use umbrella, right?
Yeah.
That was trademark. So sometimes you can just use a prefix to still use to at least trademark your brand name. Thank you, Dumebi,
Exactly.
for doing justice to this. I think that the final question I have as well, Dumebi, would be around, sorry, I think I'm moving faster than your slide, would be around IP, intellectual property. Sorry, Emmanuel, I also saw your question. It's good that you raised your hands up. I was going to skip past that, but Emmanuel, you'll speak after. IP, intellectual property. So sometimes back then, let me just give a backstory so that everyone can learn from it. Two friends shared an idea, right? They went having drinks and they're like, oh, let's do something. Oh, I have this idea. It wasn't originally the idea of the other person. It was the idea of the first person who spoke. It was like, oh, I have an idea. But the idea was not fleshed. It was just very rough. It was like crumbs on the table. So the other person picks up this idea and runs with. Now, person A, who is the one who had the crumbs of the idea, is filing for IP, intellectual property issues. It's my idea, it's this, it's that. And then the other person said, oh, yeah, you spoke to me, but I pivoted. I also had an idea around something around that. So I've done, I've fleshed my own idea out. I've moved on. I have new co-founder. The other person is saying, oh, you should have made me your co-founder. How do you approach this from a legal standpoint? And then maybe this also brings Titi back into the call. No. So maybe over to you.
Okay, yes, sir. So I think what you just shared now is the same story, or it's very similar to, I believe, what happened with Snapchat and also Facebook, if I'm not too wrong. It's a very similar story where two friends, two roommates, they shared, an idea with each other. And then one would say, oh, I did something different to your idea, and somehow that makes it. So it's well, I say it's not hard and fast in that sense. In that, okay, you were sharing an idea with your friend, but you must also recognize, and this is why information is very important, because while you are just sharing an idea and you just feel like, oh, this makes a lot of sense, somebody else now decides to implement that idea, right? Without giving you any credit, without any of that. That's IP theft, really. But if there was no agreement, there was no contract, and maybe let's assume you don't have any lawyer friend, to say, oh, look at what happened, or look at what happened, that's able to tell you, okay, I think you should actually get an agreement with this person. You guys should go into this together, you can become a co-founder. That's exactly what happened to Snapchat. In fact, the story you just narrated just seems like it's exactly what happened with Snapchat. It was very, very the exact same idea, because the actual person that had the idea behind it was the Reggie Brown himself, but nobody knows him, right? It was just very few years ago that he now decided to speak up and fight or what for whatever reason, but nobody knew him. He shared the idea with his roommates, and his roommates implemented the idea. Pretty much, it's that simple. And we all know Snapchat. It's later on, after a few years, many years, he now comes back and like I said, they were magnanimous enough to actually acknowledge him and eventually make him a co-founder. So it's not hard and fast. And the reason why I can see Snapchat even fell into that issue was because in the beginning they never, if they had what's the word, if they had recognized or understood, okay, this idea did not actually come from us directly, let's give this person a certain. I'm very sure that they would probably not have even paid him as much as they did, and they probably would not have needed to make him a co-founder, like publicly, like acknowledge him publicly and make him a co-founder publicly. They might not have needed to do that if they had maybe done a simple IP assignment agreement from the beginning, just before they launched. Or I'm just thinking out loud now, but yeah, I think it really depends on the context.
All right, Emmanuel, you want to ask your question? Emmanuel, you can unmute yourself and just ask a question. Maybe there are questions in the chat for you people.
I hope you can hear me.
Yes, we can hear you, Emmanuel.
All right. So I think I dropped a question earlier. I consulted a lawyer because I wanted to make inquiry regarding trademark and patents, but the lawyer said that we're not eligible because we are supposed to have run for some time, maybe 6 months at least, so that if we don't get anybody dragging us or claiming the trademark with us, then we can come back for the procedures. And secondly, and okay, what he meant actually was that we have to actually roll out the product to go to the market with it, make it popular for at least 6 months. And another thing I want to know is if people go to trademark any brand or any concept, if are they supposed to be allowed to continue the process if they are not incorporated, if they have not registered the business with CSE? So that if they have the business registered, somebody else, of course, cannot register the same business with CSE, which would prevent the incidence of a conflict. So I don't know if I'm making sense.
All right, Titi, you want to jump in?
All right. I'm sorry, I saw the question in the chat box that you wanted to patent.
Sorry, I think we've lost your audio. Maybe are you there? I think I've lost.
Can you hear me?
Yes, I hear you now. We lost your audio, Titi.
Oh, okay, all right. So I said that I read his question earlier in the chat box about how the lawyer said they had to wait 6 months before he can patent or I'm not sure that's what the lawyer must have said. Maybe you just didn't understand what he said because trademark is for your brand name, brand logo, slogan, and everything that has to do with your brand. So you don't need to wait 6 months, 1 month for that. You can trademark your brand name, brand logo with the trademark registry. Patent is another registry, the patent registry. And patent is the best protection for ideas, but it only protects inventions and processes. What do I mean by an invention? The light bulb is an invention, somebody's invention. Somebody invented it. So the law recognizes that if you're the one that invented something, then you should have an exclusive right to that invention for a period, I think for like 20 years, before before other people can now start replicating it. So that's what a patent is. So patent actually protects the idea, but patent is limited to an invention or a process. Software patent is not popular in Nigeria. So because the registry will usually not patent software, but we have a client that has patented an idea, but they were able to put it in a process like a map, maps and drawings and all that, which was what was presented to the patent registry, and the registry accepted it, and it's now their patent. So if it's a process, because I got somebody who contacted me now, they're developing an app, blah, 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 blah. They want a patent because they believe it's a new idea. So, well, if you can put it in a process and it maybe in maps and whatever, we can attempt a patent application at the patents registry and see if it will fly. You know that, and I told them that it's a risk. You might want to take that risk, because they're my other client too. I also was a bit skeptical of whether or not that patent was going to be granted, but he was quite determined to get that patent because he believed it was going to give him an edge. So, and now, I mean, thankfully, the patent was accepted and is now is patent. So what I'm saying is that and the issue about, I mean, I think maybe the issue about 6 months is that you must not have disclosed before a patent can be granted. It must not be something that you have disclosed to the public. And I think it's maybe within a period of maybe 1 year or 6 months. So you mustn't have disclosed it to the public. That particular idea must not have been disclosed to the public. So you have to obtain the patent first before you start disclosing it to the public. So that's it. But then you said another thing now about CAC and the trademark. Again, those registries are different. The Corporate Affairs Commission registry is a different registry from the trademark registry. Is different from the patent registry. They are different registries. So you can register a name with CAC and it's available at CAC and they have given it to you, but it's not available at trademarks registry because another person has trademarked that name. So the registries they are different. They don't use the same database. So somebody can register with CAC a name. Can you still hear me, sir? I don't know, so that I'm not just talking to myself.
Yes, we can. Yes, we can. Yes, we can.
All right. So somebody can register a name at Scott's Legal at
Yes,
CAC.
ma'am. Can hear you. Go ahead, ma'am. Can hear you.
All right. You can register Scott's Legal at CAC,
Hello, are you there?
but you didn't go to trademark it. That means, and somebody else goes to trademark it. That trademark belongs to them. So, but so we usually advise clients to do the check across the registry so that they can protect themselves.
All right.
And of course,
I think that you've
go
also
ahead, sir.
I think you've also answered Nesky question of how do you trademark. So I think that part of your conversation has answered that, right?
Okay, so I saw another thing in the chat box. Mr. Michael Kolawale, I don't know if you maybe had addressed it. The Nollywood movie was your idea and you were not credited. I think you should fight. I know you might not want to fight, but I think you should fight. If it's become a big story now and it was your idea, and the person who is now the franchise owner was in that event and saw that script, then you can fight. I think you can fight. I mean, why would anyone take your idea and just just go and replicate it without coming back to you? That's what intellectual property is about. I mean, it's injustice for somebody to have done something with their mind and then you take it and go and do it on your own and then you earn income from it. It's injustice. So I think it's something, if you're willing, I think you may need to fight it. It's not good enough to just keep quiet and know that idea was yours. So that's what I will say about that.
All right. So you have the slide. I've opened up the next stuff so that you can continue.
Okay. All right. So this investors and advisors, we know that there are some investors. I don't know if they are currently on the call, but there are some investors and advisors also that signed up for the Umbrella Saturday. So we just chipping something for them also. We said legal hygiene affects valuation and risk. So as an investor, you must always look at these people okay when it comes to their legals. Insist on clean incorporation records, IP protection, especially for tech or product startups, because technology idea is a broad field and a lot of people play in that space. And you have to be able to know who owns the IP. And of course, legally binding equity terms, whether you want to use a safe, a shareholders agreement, or a convertible note, a convertible debt, whatever it is you want to use, you might need to ensure that you put those things down. Who owns the code? Who owns the brand? Those are you can find those information in the in the founders agreement. The IP assignment might already be contained in the founders agreement, or if it's not, then you might need to insist. That's already a red flag. You might need to insist who owns the brand. Who owns this brand? That question needs to be answered. For advisors, help founders set up legal systems early. we've gone back and forth on in this call about how important the legals are. I know some people already agreed with us that they're not business. So, I mean, very, very fundamental. An advisor, you need to advise them legals, particularly if from our data we see that everybody wants funding. You can't want funding and your legal documentations are zero. You might as well. Yeah, you might be able to get funding from your parents and your families, but institutionalized investors, they won't even bat an eyelid, they won't even look at you twice if some of these things are not put in place. We said watch out for unclear founder roles. What they are. The roles are not clear. Undocumented staff IP, because those working with you also will come up with some IPs while they are working with you. Those IP also has to be assigned, so that they don't say, okay, well, it's mine, and there's no IP assignments. I mean, I'm a staff, but this thing came from my own idea. You have to be able to protect that also. Improperly structured fundraising also, you can also look at that as an investor when you're coming in. Look at the previous investor, what was given to them, and how was it structured. We also said we encourage founders to create a legal folder. You should have a legal folder that has all your CAC documents, agreements, IP. And when anybody asks you, you can just bring them out and say, this is it. I mean, I told you about a client of ours. I don't know if I've seen anybody that meticulous. He registered with, Young Directors Association, all the associations that they, it was a prop tech startup. Every association relating to property that don't even relate to technology, he registered. He said so that when the regulators come for me, I can bring out all my papers and say, look, I'm a member of this body. I'm a member of this body. I thought that was a most intelligent thing to do, and so collaboration team advisors and investors can partner with legal support teams to offer bundled services also. So we can also as an investor, you also need to have advisors and legal advice on the startup that even if the startup has done their own due diligence, you as an investor ought to do your own independent due diligence. And so I think that
All
takes care of
right,
that
Titi,
slide.
please let's have Julius because I think his question is very important.
All right, Mr. Julius, go ahead.
All right, thank you so much. So, my question touches on the trademark and patents and conversation we are currently having. So, basically, I think part of it has been answered in a way. However, where I want to come in, where my question will come in terms of patent is the side of, replicating an innovation or something like, something like that. Say, for instance, okay, let me use this as an example. You have a company name that goes by, let's say, Bridge Logistics. So it has been incorporated as logistics, or yeah, known as the Bridge. On the for six, would also be able to bridge up, which is the version of the app of the company, or it has to be trademarked set differently. And would the app Bridge Law be patented to this effect? Yeah, quite all right. This app, let's say, okay, let's say for instance, of its kind, let's use Nigeria as a case study. So this is the first of its kind in Nigeria, but it has existed somewhere else. Then it means somewhere outside the country, maybe in Western world or something like that. But this is first of its kind, where it's more like a replication of that particular idea of innovation in another country entirely. And Nigeria as a case study would be due for patents. What would you say?
Okay, let me answer. The first one is you have a different name as the business name, then you also have a different name as the app. Should I trademark? Is one sufficient, or should I trademark both? Well, I would advise you to trademark both. Why? Because it's like Coca-Cola and Coke. Of course, Coke is a short form of Coca-Cola, but Coca-Cola is a registered trademark, and Coke is also because both of them are different. So, it's just wise to, trademark as many, brand variation as you have, So that would be my own advice. On your second question, if something exists already somewhere and you now bring it into Nigeria, can you patent? I mean, patent ordinarily is not something that is so easy to get. Like I said, patent relates to an invention, and it has to be. It is not. That is when we look at the state of the art. Look at the state of the art. It's it look wide. Like it has to be something that has not existed before. If I go and say, okay, they do biros in Germany, then I want to start doing biro now. I want to patent it. May not likely, fly, So, although I might need to maybe just look further on the interjurisdictional application of patents. I know trademarks don't apply interjurisdictionally. That means if you have Apple, I mean, in US, you might have to also register the trademark in other countries. So it's not interjurisdictional, but patent, I need to find out whether it's interjurisdictional. That is, if I have a patent, I've already patented something in the US, is it binding on Nigeria? Is that, I mean, patent binding on Nigeria? My earliest answer, my top of the head answer will be yes, because patent is usually something that belongs to you. Although Nigeria is funny, people just replicate. I mean, I saw a question in the box where somebody, I mean, a company already existent outside the country, we now register the same name here in Nigeria. So, I mean, what's the implication of that? Of course, because we are very far away from some of those countries. That's why they don't. I mean, you look at Balenciaga as a trademark, and you see the kind of injustice Nigerian designers have done to that kind of name. They just put Balenciaga, balance. They just do all kind of things and sell. But the likelihood that Balenciaga is going to want to come and enforce those rights in Nigeria is slim. Not that they can't, but it's slim. So, so that interjurisdictional thing is also applies. Whether I know trademark is not interjurisdictional. You have to come to the country to also register the trademark. Any country you want to move in, you have to register the trademark. So it's not, but patents. My belief is that it should be interjurisdictional. That's my belief, but I can find that out more. Somebody's asking me how. Okay, Gen Z thinks. No, but it's the truth. I mean, that's usually some of the challenges we have in the world. So, but I think I answered your question, Julius. All right, thank you.
Right. Yeah,
So,
Ebuka has a question.
Mr. Yusu, I'm going to okay, I'm going to beg you not for us not to move into this part of this part in it. Because
Okay.
let me confess to you. This part is what we wanted to do before. But when we those we can have those different times about safeguarding your brand and identity. So we can maybe another time.
All right.
There are a lot of questions around IP, so we can leave this part. So we can just stop here. This was what we were going to focus on before, the brand identity. But when we saw Mr. Yola's post on LinkedIn saying that founders will come and learn how to, so we knew that, I mean, it's like he had put us in a corner. So we had to quickly redo our slides. So to have a first part and a second part, but I doubt if we can take that second part. The day is far gone. So, but we can have it. Maybe you can schedule us for another Saturday, maybe later in the year or something, to come and speak to brand and brand protection generally.
Thank you very much, Titi, for rubbing yourself into that publicly. You know you're coming back. So, so that's good. Ebuka, let's have your question.
Hi, good afternoon, everyone. Thank you very much, Mr. Ayola. And
Good
Titi,
to
you've
see
been
you
doing a
again.
great job. I hope you guys can hear me.
Yes, we can. Good to see you again, Ebuka.
We can hear you very well, sir.
All right, thank you very much. Let me go straight to it. As a startup founder, still in the idea stage, trying to set up my team, is it okay to, outrightly just share the idea with these guys and let them know, okay, this is what I'm going into, and would you be interested without them signing an NDA, or maybe bringing them to sign the NDA later on, or do I have to make them sign the NDA first before I let them in on the plan? Which do you think is legally advisable that will protect me and my business? That's it.
If you ask me, I will tell you to. I mean, there are some people you can control when it comes to NDA. Your friends, people around you, people that are talking to, other startups. You can control those ones and insist on the NDA. There's some people you cannot control. You want to talk to an MTN. I mean, oh yeah, of course, an MTN, of course, they should respect an NDA, but you might not be able to compel them to sign an NDA. You know, like I said, I have a way around that. But I mean, there's some people you can compel. So those people that are within your reach to compel, please don't say anything without an NDA. I mean, I've had business discussions with people now, and now I'm trying to develop other ideas, but I'm seeing myself going to that idea that was shared with me, and I'm like, this was, and I've signed an NDA, and I'm like, this is going to breach that NDA, so I need to find a way around. So with an NDA, I know I'm bound. That disclosure, I'm bound by all those ideas shared with me. I'm bound. I can't, you know. So if it's people within your control, companies within your control, you should insist on an NDA. It's a very simple document. They sign it, and then you can now start divulging and disclosing, so that in case anything happens, you can immediately write a cease and desist letter and all that. So my own, but if it's a big company that, you know, if you put an NDA before them, they'll just ignore you and shun you. So that you might need to find another way to pitch your ideas to those ones.
All right.
Okay. Sorry for coming in again. Okay. I've seen your contact.
Go.
So I have to like get them to sign that NDA, right? But
Yes.
in situations where I don't have this NDA sitting around. I don't just walk around holding an NDA, and
Yeah.
it's just to maybe get their contact. What if these guys are not going to be interested and things like that? So these are questions that come into my mind. Some of these people I meet them by chance, and I don't want to miss the opportunity in meeting them. But you think
I,
I have to like,
Now,
sorry,
I
wanted to say
understand
something.
that. I understand your question, and I understand your dilemma. You're talking about maybe you meet somebody at a maybe like an event, like a tech event, a big
Yes,
person, and you
yes.
quickly want to pitch your idea to them and all that. You know, well, the truth about it is that life is a risk. I mean, I have to admit that. So, you know, sometime I mean, we've had these questions like really, really severally. You can pitch, I mean, as much as you can, maybe not divulging the details and say, okay, I don't know if I can send it to you by email. I don't know if I can send it to you. I mean, when you have given an idea of what your product is about, then you can now say, okay, I don't know if you can send it, if I can send it to you by, so that you can now maybe tidy up some ends before you now send it. So I'm only saying that, yes, I mean, you are right. Some opportunities happen where you meet people that you believe that can, you know, listen to you about your, you know. So, but of course, life is a risk, but you also have to be very careful, you know, who you divulge to. So, but if you have, you know, you told them just about enough for them to listen to you, then you can carry the conversation to, I mean, to written
Do
forms.
you think ChatGPT can prepare a very good ND or is a standard ND? Do you think ChatGPT can do that?
Mr. Ibuka, what do you want me to, what kind of answer do you want me to give to that question?
I know you have said that they are really smart, but sometimes, you know.
The truth
But
about it is that
to be
if
honest,
if
because
ChatGPT generates a an agreement for you, you can't understand it. A ChatGPT can generate an agreement for me as a lawyer, and I can look at it. I can look at it and say, "Oh, well, no, this is not right. This is I should delete this because I'm a lawyer." But if ChatGPT generates an agreement for you, and you're not a lawyer, you might assume that some things mean and they don't mean what they mean. So, I mean, lawyers can use ChatGPT and, you know, to design better agreements, and I agree with that. And even at that, it must not be used slavishly. You mustn't just use it as you wish. But for you don't know anything about law. You have not studied law before. For you to rely on a ChatGPT agreement, I think. I mean, I'm not sure about it. That's what I'm going to say.
All right.
I'm not sure about it.
Let me
All
ask. I
right,
have
that'll
two
be all for
questions.
now. Thank you.
Thank you, Ibuka. Titi, I have two questions for you. I know that we're about to round up the session, but
All right,
um,
sir.
Mami says, is company culture part of legal for startups?
What?
Lami says that is company culture part of legal for startups?
Company culture.
Yeah.
Oh, well, yes, because your employment documents really should be drafted by a lawyer. We're talking about your employment contract, talking about maybe your policies, and at least even if they are drafted by your HR, maybe a legal person can also look at it and give an eye and say, okay, some of these things and all that. So company culture, yes. I mean, starting from the offer letter to the employment letter, they are all legal issues. So you might as well run them by a lawyer to be sure that you are good to go.
All right. My
We
second question. My second
Go
question.
ahead.
How do founders protect themselves from VCs, right? I had a call with a founder sometime when he, big out of Africa, and he was saying to me that, sorry, Tita, I don't know if you can still hear, but I'll mute you just because your son is there with you.
Please go ahead. Go ahead. Please go ahead.
All right. Um, and he was saying that, they pitched to a VC, they were interested in them, and all of a sudden the VC now, so the VC asked him a lot of questions, and in the bid for the founder to just, I'm looking for money, I'm saying a lot, I want you to know how my process work, I'm telling you about my technology, I'm telling you about how I've, journeyed and all that. I'm even showing you my process, I'm showing you my screens, I'm showing you how everything works, right? And then this founder was telling me that, oh, now the VC is building a similar product. How can founders protect themselves from angel investors who they pitch their ideas to, VCs who they pitch their ideas to? The other day, there was a very big drag in one of the communities I belong to, where a founder said that I think he raised money from an angel investor, and then the business shut down. Now the angel investor is asking him to refund all the money, and the only thing he got out of that investment was, I think, maybe a gas cooker or a gas cylinder. I can't remember the story vividly, but he's also saying that when the investor was getting into the business, he also should have known that it's a risk. So how do founders protect themselves? How do they put some of these conversations out there? Is what I want to also ask you, Titi. I don't know if you heard me, Titi. You're muted.
Okay, thank you very much. The first thing I want to say is the VC who the idea was pitched to, he had disclosed quite a number of things, and then all of a sudden the VC has gone to start building something similar. I think some things also, like I said earlier, you might have to fight some things. Now, the truth is that sometimes you didn't protect yourself, but intellectual property is protected. And sometimes it's even protected by under common law. That is what we call passing of. And you can always find a course of action for something like that. I mean, because, like I said, that is unfair and unjust. Why should you pitch your idea to a VC and then they go to start working? Yeah, you can come and say, they can come back and say, look, no, it was not exclusive, but they showed interest. You can lay the factual background. They showed interest. They were going to, then all of a sudden they are building. So some things they can't deny that they got that idea from the person. So some things you need to fight. A letter, a cease and desist letter, a threat of action, can actually cure a lot of things. So I don't think founders should always just keep quiet. I saw in the chat that the movie that we're talking about there was The Merry Man. How now? You can always fight such things. So I know when it's a Nigerian culture, we don't want to fight. We just want to just keep quiet and go away. But sometimes some of those things don't work and they don't allow us build. They are going to do it to other people too. But I still think that you mean some like someone said someone was saying that okay, maybe the lawyers can take it on a no win, no case. Yeah, I mean, it's something that people can. I can. I mean, I can. I mean, I'm not. I'm passionate about injustice. I mean, why should you do things like that? So I can actually take it up because I don't think it's right. So how can they protect themselves? Again, like I said, I have a personal way that I usually, but you can contact me for that advice personally. So, but I'll say that about that. The other one about the angel investor who wanted a refund. Were there no agreements? I mean, was there nothing written on the terms? And what happens if the investment fails and all that? There should have been a written document that would have dictated the terms. So except we don't have all the facts, but if there was an agreement, because angel investment does not necessarily mean that it's not documented. There should have been document, and that's what we usually warn against some of these things. I mean, you are dealing with an angel investor, have documents, okay? Talk to a lawyer and all that. I think, we need to, these things cannot be overemphasized. Let's talk to a lawyer. Let's see, how we can, ensure that your rights or the angel investors, responsibilities are covered by agreements. So that's what I'm going to say about that.
All right, thank you very much, Titi, for joining the call. Together with Dumebi. We're going to go into the breakout room, which I will open now. It's like a deal room, where if you're interested in the services that Scott Legal can provide, you can have a conversation with them. If you have legal issues that you don't want to say on this call, you can actually say them on that call with Titi and our team, and then they can also provide some solutions. So the breakout room will kick off almost immediately.
Okay, so but before you break out, I must also say that our services are not expensive. I mean, Mr. Yola, we've been in discussions, and we've also provided some service for you. I'm sure you can. So because of our experiences with startups, we usually sorry, hold on. We usually, like to price, as reasonably as we can. Of course, some of the challenges we also face is that no matter how you price, sometimes, people just don't want to take up the service. But I will encourage you, rather than building a loan, going alone, having a lawyer is a big priority to you. So and you should see it like that. Some of these issues we see, somebody is, and then could have been avoided with the service of a lawyer. So I would allow if I
All right, thank you, everyone. Let's join the breakout room. The breakout room is open now, so we can join it. It's called the deal room. So just join in. All right. Some people are already used to the breakout room. I can see that people are here already. So it's a deal room. The timer is open. I know that there are some questions for Scott Legal. So Titi, just tell us about some of the things that you offer as services. Maybe can do justice to this as well. What are the things that you do for startup founders from like the beginning?
Okay, I'll say some things, and then I'll allow you maybe also add some of the things I don't remember. The first thing is that, because of all the things we have said, we have a startup package for incorporation. So we don't just incorporate, we get you to do your search at the trademarks registry and at CSC's registry, and of course even a domain name, so that you can secure the three at the same time, and so that you won't choose a name that goes with CSC but does not go with, and there's no domain name, things like that. So we provide the TIN, the tax identification number, which is one of the things you'll be required, to present for your bank account opening. Skumu is also one of our registration services. Then we have some value-added service that we also add to our registration package, which is corporate governance advisory and then of course general legal advisory for a month. So we usually add all of that to our startup package so that we don't just leave you to yourself, just register a company and you just go away. But we can assist you at least to the point where you get your bank accounts details and of course whatever else is needed at that initial stage, and then a legal advisory for about a month so that we can also help you, stabilize till, and then also some of the other services we render are the employment. We have some employment contract services where it's either you get us your offer letter and maybe a good employment contract that can protect you. We're talking about added non-compete clauses, non-circumvention clauses, so clauses that will protect you, against your employees taking some actions that might eventually affect your business. So we have the employment, then intellectual property services, of course, on their own. Also, we also render those services to trademark. We can also look at the different classes because don't forget that the Paystack ZAP and the ZAP Africa Challenge is a question of class. ZAP registered in one class, Paystack ZAP registered in another class. So when ZAP Africa, those are some of the things. So because of our experience and background with IP, we can all look at the classes and say, okay, we recommend that you register it in this class, this class, this class, and this class, so that in case anybody wants to register in another class, they won't, because once you register in one class, it doesn't cover other classes. I mean, I don't know if you get what I'm saying. So we also do trademark service. We also have, we also do registration US company, or you want to incur into any African country. We have that service now in place where we provide, services for you to incur into any African countries and the US. We want to register a business there, and also the business support to ensure that your business stabilizes in those countries. So those are some of the services. We also have shared costs, what we call the shared cost package, where if you have like 4, 5, 6 startups, they can come together with our retainer package. Then we can provide legal services to the 6 of you month by month at a reduced rate because of the volume. So we have a list of services we provide for you month after month, and and you can share the cost. Across the 6 or 7 or 8 or 5 of you. So maybe I don't know if I left anything out, but you can just help me add to that.
I think
Do
yes. So in addition, I think what we can also do is maybe for anybody that's interested, we can share what our retainer packages look like for startups. Um, yeah, and as well as the shared cost service that we also provide for startups. That's
All right.
about it.
Thank you very much. I don't know if there are questions for them. I'll just add an extra 30 minutes for questions. Julius, Richard, Emmanuel, Ebuka, Kome, Nami. I don't know if there are questions. You can just raise your hands or mute yourself. Let's quickly have it. Faba, Esther. Anybody with questions? Tunji, any questions for Skull? All right, Julius, let's go. You can quickly unmute yourself because of the time.
All right, thank you. Yeah. So I was going to ask about, going back and reversing back to the discussion we had on advisory board, board of directors, and all that. Yeah. So I wanted to ask a question around how retainership, or let me say retention rather. I think I prefer that. Um, Retention, like how do we retain? Of course, we know that it could be very difficult for a lot of founders, entrepreneurs to have board of directors set up at the initial stage. I mean, at the early stage. So, and I think it also makes sense that we look into the aspect of advisory boards if you can actually set up a board of directors at the initial stage or something, or maybe at that point where we may actually need them. And at the same time, we are also conscious that we don't want to share, we don't want to just to distribute shares, where they just come to be, owners in the company and all that. And of course, it's not something out of place. It's not something that is not attainable. But then you're very cautious. You don't want to just, throw shares all around just by, having them on board just like that without having to contribute meaningfully to the progress of the startup. So now the question revolves around how do we ensure retention of board advisory boards or members on the advisory board, and given the fact that we don't want to throw shares, you know, around just like that. No, I just need practical insights because I think for me, this is something I've actually been thinking about for a while now. And I'm being very, very cautious and very slow about it. Thank you.
Okay, thank you, Mr. Julius, for your question. You want to set up an advisory board, but you don't want to deal with your shares, in such a manner that you're just giving out shares and all that. Well, like I said, the board of advice, the advisory board, they don't necessarily have to have shares. It's not necessarily for you to tout shares to the advisory board. A lot of times, advisory board are just a number of people, maybe in your industry, or people with very good knowledge of one thing or the other. Maybe one legal advisory, one somebody in your field, and two or three more people who you can just consult for whatever it is that you are doing and all that. You can have maybe like a board of advisor meeting, maybe once a year, twice a year, and they'll just run what you are doing by them, and they will advise you and all that. So you don't necessarily have to, um, give them shares. Now, board of advisors, the advisory board is different from advisors. Like you get maybe like let's say a legal advisor now, and the person wants to provide like legal services to you, and maybe in exchange for equity. So that's something different. That's what I mean. Yeah, that might also be someone on the advisory board, but an advisory board usually I don't want to say ceremonial, but just some people that you have that you can just run what you are doing by them oftentimes. And that's why I said sometimes people choose people that they don't really have time for them and all that. So they are different. I mean, we must be able to separate the two. If you're talking about advisors, like maybe you need financial advisory, but you can't pay for the service, and you are trying to see if you can pay with equity, then you can have that discussion with the financial advisor and say, okay, I want this, you want you to provide this service. If they are agreeable to it, then you can. That's when you talk about equity. So again, in dealing your equity, you have to look at what you have and what they are bringing in. Ordinarily, even investors, when they bring in money, they don't take more than 10%, a lot of the time. So I think, if you're going to have that, you can look within that range of 5 to 10%. If they are agreeable, because, an advisor who wants to provide their service for equity is also an investor. You'll be now that's also an investor, but they are not investing money, they are investing services. So they might need to consider it to themselves and say, okay, is this beneficial to me? Taking this equity in exchange, how am I sure it's going to, it's going to yield me the effort and all that. So that's a business decision for them also, whether or not they want to agree to your terms. So, but I don't know if I answered your question.
Yeah, this is really brilliant and practical enough. Thank you so much.
You're welcome, sir.
Any other question? Any other question for Titi so we can close out the session? All right. The breakout session ends now. I'll be ending it now, just in case there are no questions. Thank you everyone for joining. We'll just return to the normal room and then we can start to close out the session. Oh, Ebuka, sorry, you can ask the question on the other side. I actually just saw your hands up. Sorry, Ebuka. Hi, everyone. Welcome back. I know that Ebuka had his hands up before we left there, but apologies to him. I moved quickly to this place. But once he comes in, we can have the question Ebuka has. I think that for me, it's been a successful month of sharing knowledge in the month of May. We've had series of sessions from finance to valuation, and now currently law, legal, right? And Titi, just a very quick one. Everybody says it's important for you to do X, or it's better for you to have X. The valuation guys told us how it's important for you to, do your finance, have your finance in tax. Everything seems important to a founder. Today, now on this call, you've told us that having a legal person from day one is also very important. What do you people want from founders? I removed I
Well,
removed the other part of Shefe Pamini. I removed it, but what people want from founders? Because everything
well, the
seems
truth about
important.
the truth about it is that I understand the challenge of founders. And again, my own personal beliefs are that doing business is not such a difficult. I mean, it was just yet how many days ago we heard that Amoke Ogie had made over 200, okay, how many billions of naira just on child deck and all that. I mean, Amoke Ogie is just a food restaurant, just serving food and all that. So I know doing business is not that complicated. Let's not lie to ourselves. To do business to make money, you have population, you have the country has, I mean, a teeming population that can access services and all that. So doing business is not an issue, and making money is also not an issue. Of course, as advisors, we will always tell you what we believe is best. I mean, and I run these trainings for SMEs and MSMEs also. I mean, I'm in conjunction with LSCTF, where they're resource people also. When we talk to small businesses, as a matter of fact, they are also engaging us to register companies for small businesses. Because the truth about it is that, yeah, I know, and I can't argue with that. But I can tell you for free that it's my belief that also that, as a startup founder, because yes, I can compare the business to Amokelge, but you're not Amokelge. Amokelge is selling food, and that's what it is. People come in, buy food, and go. We're talking about, I mean, they are not even accessing any investor and all that. So, but we're talking about your business model is such that, as a startup founder, your business model is such that you have a lot of things you are thinking about beyond regular business. So maybe that's why it seemed a little complicated, but I don't think it is. I just think, it's about what exactly do I want to do. But I will still stay with what I said earlier. I believe that legal should be, if a business is a legal creation, then business legal should be, I mean, it's part of you as a startup founder, okay? Should be part of the first things you pay attention to.
All
I
right.
think so. I may
Thank
be wrong, but I just think so.
thank you, Titi. Ebuka, you had the question, so please let's quickly have your question before we call it a day.
All
Ebuka.
right, sir. Thank you very much.
Yeah.
Titi, you said you're not expensive. You're very
Yes.
affordable for us. That is my question. Like, how much per se, give or take? Because um, I'm still starting, or I'm just starting. I wouldn't say I have so much money at my disposal. And you say it's very important for me to get a legal team on board starting off. So, how much will this cost me?
Okay. Off the top of my head, if you are, for example, if it's a shared cost, maybe you have two, three, four, five founders, our retainer package will cost you less than 80K a month, which I believe, I mean, assuming you are even employing a lawyer, I mean, on your team, you have to pay them more than that. Well, I mean, which you definitely will not want to employ a lawyer. But so at the shared cost level, I mean, with 80K, you can have access to our services, weekly meetings, reviewing, I mean, some things for you and all that. So that's what I call cheap. because yes, I mean, even if you want to employ an NYC copper, you won't pay them 80K. So, but we can bring our wealth of experience to you. That's in the shared cost package. For the just retainer package, um, that's an average of, let's say, maybe like 120K a month. That's for the retainer package itself. That's an average of 120K a month. So that's what I mean, I refer to as accessible. And I mean, with that, you can have access to continuous legal services. You can ask questions. You can. So I believe that my own thought, I may be wrong. Like I said, startup founders are bootstrapping.
No,
So
you are not
what
wrong.
I
You
what
are
I
not
think
wrong. You are not wrong.
what
Go
I
ahead,
think is fair. You might look at it and say, I don't have 80K a month. Okay, so but the truth is that there's no way we have to price it one way or the other because we are all in the same market doing business. So we have to price it one way or the other. We can't price it less than we can provide the service and a good service at that. So that's what we call, affordable service.
Thank you very much.
I'm sure you can find it that
Thank you so much.
well. Although some people don't even do startup, we have startup packages because we deal with startups. So there are startup packages that we have put together so that we don't charge big companies. That same retainer can cost a multinational maybe like 8 million a year or 10 million a year, or something like that. So, but because we deal with a lot of startups, we have to consider their own income and their flow. So that's why we put it like that. So that's what I call affordable.
Thank you very much, Titi, for doing justice to that question. I can tell you for a fact that since Scott Legal came into our own life at Umbrella, it's been very, very easy, to do business with them. And I would advise that founders also look the way of Legal. For us at Umbrella, Legal has always been a very important thing issue. It's our top burner. We ensure that, our corporate governance, our compliance issues, everything legal was thought through, right? While we were doing the business as well. It's good to have everyone on the call, and thanks for joining the May edition of Umbrella Saturdays. Um, Thanks, Titi and Dumebi, for doing justice to this. They are actually reachable. They are on the Umbrella Partners dashboard. So as a founder, once you sign up on useumbrella.com, you would also have access to them. Their services are even pretty cheaper than what she has said on this call. That's if you go to them directly. If you go to them through Umbrella, you probably get it way cheaper, right? So we are partners for a reason. Partners to ensure that founders scale, right? And that's the most important part of Umbrella. Ensuring that you get your right verification, ensuring that you get vetted founders as an investor to invest in, and ensuring that founders have the right skill set to scale their enterprise. We meet again next month. Very interesting month because at least we have the whole 4 weeks of the month to do Umbrella Saturdays. We're going to have a whole lot of speakers, amazing speakers, experienced speakers, speaking on several aspects of Umbrella Saturday. And I'll be very honest, you should invite your friends, invite people to come in, share the form because we use the form. We're data driven at Umbrella, so we use the form to be able to tell what interest founders are looking for, and that has made us be able to create exciting content for you all. Till next week, Saturday, till we meet again. I remain your host, Ayola, and then thank you for coming. I know you guys put Titi on the hot seats, but she did justice to the topic. She's coming back, and next time when she's coming back, I'm going to put her on a very, very, very interesting conversation. How to put legal in investors' conversation. Titi, you already have the topic. How do we bring in legal in investors' conversations as founders? So I will work on that and I'll share you the date. I think you'll be back in August. So we'll have you in August together with Dumebi. So it will be a joint session with Dumebi. where two of you are speaking to the entire umbrella community. We're growing. The numbers for Umbrella Saturday is growing. And then, well, the videos would also be live on YouTube. I would share the link. We already have two of the previous episodes on YouTube. If you missed it out, you can also watch it. Snippet of it will also be shared via email. So you all can have, share the experience, speak about it, share with friends. Titi, one question someone asked me personally was, do you also have an understanding of the nuances across Africa? Can Scott Legal also attend to my need in Ghana, Kenya, South Africa, Rwanda, Uganda, Cameroon, in the rest of the 54 countries in Africa beyond Nigeria, right? I know that some of the conversations spoke majorly to the Nigerian founders. They could relate, but also founders outside the Nigerian landscape are also asking.
Okay, all right. Thank you for that question. In fact, it's a service that we have just, we have a partner who does that across Africa. We have just partnered with them, and we are bringing that service to all our clients all across Africa, whichever country you want to enter to. That's our. As we went to the end of the slide, we had introduced it. So it's one of the things where we do now. Any African country you want to enter into, we have, you know, um, I mean, we provide all the services, incorporation services for you. So that's what we do now. And even in the US, if you're going into the US also, we are there for you. So that value-added services, we are going to be pushing that also now to as many startups as possible. You want to get into an African country, particularly with the PAPs and what they're doing with the AFCTA. African trade is supposed to improve. So if we're looking into getting into African countries, scaling to African countries, we're your best bets.
All right, thank you, Titi. Just to also add is that next month we'll be having the deal rain, which is like Umbrella's deal room, for founders who are already investment ready, um, who have also listed on Umbrella. We'll be having an investor only conversations with founders. It's like a deal lounge where founders and investors will pitch. So of course, emails will be going out to that effect next month. We're also launching what we call the Tech Garage, where founders can and investors would come have conversations, open-ended conversations. This is not you pitching. This is just you saying and expressing what you think. Because again, founders have their meet around investments. Investors have their meet around founders. Let's meet in a meeting point, right? So the Tech Garage is there for you to have those honest conversations. It's a podcast. It will be recorded, uploaded, and then we will share that with founders. Thank you once again for joining the call, and have the best of your week. I know we usually will keep everyone on this call for 3 hours. We've done that consecutively 3 Saturdays. We're also going to look for how we would reduce the timing to maybe 2 hours. But of course, nobody has complained. So it seems like the conversations are worth the time. And what's the investment? This is our own investment to the community, and we hope that everyone has gained something insightful. Have a great day and be great.